Good morning, good morning, good morning. It's Thursday. It's November 21st. I can't believe it. And today is the day that the Lawnard shop launches. So, I love that my cable is just here. Look, streaming is dynamic. We don't pretend anything else. But for the replay crew, go ahead and double check the timestamps. Everything's down below. Today, we've got to talk about new orders in the Diddy case. I'm sure there will be more, literally as I'm streaming, because that docket can't stop, won't stop. There are also a bunch of new filings and new orders in the Bryan Kohberger prosecution in Idaho. And that is popping off. I don't know if we're going to get to everything. We're going to vote on what we cover. There are so many filings. A lot of them are similar. We're going to go through the main point and then we'll go filing by filing, but we have lots of orders from the judge. We also have the launch of Lawnard Shop 2.0. There's a lot of other stuff going on in the news. A lot of it I'm going to touch on real quick in quick bits this week. And we're going to need a whole Real Housewives episode, but if you've been missing the pop culture, a lot of it is in quick bits as we're going over it quickly. Those drop on Monday on the audio feed, on the Quick Bits channel, and the rest. I have a lot of physical things to show you here today for Lawnard Shop. So we can do one of two things. We can just get into the shop first and be excited, or we can get into Diddy stuff first, or I'll ask you what you want to do first, because there are so many things pending today. We need to know. So I'm going to ask. I'm going to just put up a poll. And I'm going to roll the intro. I'm going to see where I can get my cord to disappear. But are we wearing Lawnard? Are we wearing Lawnard stuff? Yes, we are. Yes, we are. Of course we are. Let's roll the intro and let's get to getting. It's been a busy week for Team Baker. It's been a busy few months for Team Baker, and do you guys want some of the behind the scenes on that? We'll talk about it.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the Lawnards unite to talk about facts, not... Let's get into it.
You guys are overwhelmingly like, girl, get to the shop. Tell us what we're doing, and then we can focus. Look, I know that our audience is as neurospicy as I am, so I get it. It's like, tell me what is in the shop, and then I can focus. So we're going to talk about new merch, and then we will talk about all of the law stuff. So thank you for indulging me. Oh, I'm dropping my cups. You guys know it is not always that I should have run this up the back of my sweatshirt. Streaming is dynamic. We don't always take a full pause to talk about the shop. Yes, we are still running the shop on Shopify. They're not just a sponsor. They're actually what I built the Lawnard shop on. For those of you that are newer here, and by newer, I mean in any time in the last 3 years, the Lawnard shop came about because the Lawnards were like, can we just put that on a shirt? Just put it on a shirt. And so I called my friend Parker and was like, Parker, I want to put it on a shirt. And Parker's like, I got you. Parker and Damon run an incredible warehouse out of Louisiana. They teach crafters how to run Etsy stores. I buy all of my craft things from them. They're absolutely incredible. And so instrumental in the journey. I was like, can you just tell me how to do this and not get in trouble for not paying sales tax somewhere, because physical merch is a whole different thing than just creating a video. And help me. And literally the two of us built the Lawnard shop at 2, 3 a.m. Because it's when we had time to do it, and created Lawnard shop, what was version 1.0. It grew from there, but we built it together on the phone on Shopify. And I was like, we'll figure it out. We'll figure it out. And so from there, we have built to now Lawnard shop 2.0. And some of the things that not only Team Baker was feeling frustration with, but some of the Lawnards were feeling frustration with, was not always the consistency that we wanted. And we couldn't customize our offerings the way we wanted to. And to do that, it takes an entire different team to help source goods. And we wanted to source goods in the US, to move to a larger warehouse that would ship internationally, to make sure that we were accommodating for all of the international rules and regulations. Y'all, the rules. Y'all, the rules. And Team Baker will attest to the fact that Team Baker's got their foot on the gas. Team EDB has her foot on the brake. Like, but rules. Like, we've got to explain to me how the rules are going to work and how we're going to make sure that things are printed in the right ink, that like the EU's not going to get mad about it. Can just help. And we brought on two wonderful teams, not only a design team that is helping us source things. I will tell you that I sourced from a sensory aspect first. So it was not, do I love the sweater? It was, how does it feel? And so we started with a sensory aspect first. So everything is softer. Hats are softer. Hoodies are softer. But in true EDB fashion, as we started working on this project, I also started covering trial. And so things got delayed on my end. Emily, when is there a sticking point in the process? Me. I am the sticking process in everything. So as we were getting ready to launch, we are also getting into holidays. So if you see something that you're like, I wish we had XYZ, don't worry, there are more launches coming in the new year. This is our first launch with a whole new process. So if you see something that you are missing from the old shop, we have launches planned out for next year. But as we're running into holidays, we are also running into availability and timing, and we didn't want to push timing. So we decided to go with a smaller launch to get things to you. So if you are missing a zip up hoodie, don't worry. We've got you in coming launches. That's why I told you with the last launch, don't worry. Grab the stuff you love from Legacy, Law Nerd Shop 1.0. We've got stuff coming in the new shop. So this is our 1.0 version. We're also working with new distribution all out of the US. So we are distributing everything from the US, and we are making sure that the things that are being shipped will get to you in time for the holidays. Shipping is on the website. So all the shipping times are on the website. All of the sizing is on the website. We have a whole contact page if you have questions on the website. I will tell you that all of the hoodies do not have tags. They have a printed tag in the back. The hats are very well stitched, so there's no uncomfy in the head. I will show you the back of the hat in a second so it doesn't pull on your hair. It's all really rounded corners. And the things that we put on the sleeve are all printed on instead of having tags on the sleeve. So we really built the things that we wanted for A, all of us to be sensory and comfortable, and B, to make sure that we could get the merch to as many Law Nerds as possible. In some of the extended size ranges, there is a little bit of color variance due to availability. It is something that we have pushed manufacturers on and is a unfortunate, frustrating reality, but we are continuing to work on that as we move towards launches. We wanted to offer something that was comparable instead of offering nothing. So you'll notice that there. For the hoodies, these are different in the non-extended size range. And when you look at our website, you'll see them noted. They are a drop shoulder and they are a bit bigger than our previous hoodies. I sized down on this launch. So take a look at the sizing, but I've sized down in our hoodies because these hoodies are squishy and roomy. So I personally was really happy in a 2X in our last launch and vary on these between an XL and a large in this launch. So if you guys have any sizing questions, let the crew know, but we will be able to accommodate some of the sizing things. So look at your, if you guys are saying, what if we already ordered? Go look at your order. If you need to send a note, there's a contact page on the website, but I did size down. But if you like a generous hoodie, you'll be happy. It just depends on what you want. So I'm going to show you the shop on lawnerdshop.com. And then I'm going to show you some of the physical merch. and then we will roll into the law. Cole asked, when will we need to order to get it before Christmas? All of the ship dates are on the website, so you will see those there. I will need to ask exactly what that date is, because my brain is so full of information that Let me make sure that is. All of a sudden, we are having like aspect ratio issues with Chrome that we didn't have before, and I don't know what that is about. Emily will have to figure it out. So welcome to Law Nerd Shop 2.0. We have, again, the hoodies, the three hoodies that we have launched, which is the heart on my sleeve hoodie. This is a physical patch. I'm going to show you. I have it in office. This on the sleeve is a physical patch. It is like a tattoo styled patch on the arm. That is what the patch looks like, but it is a physical patch on the arm. I love it. It is so cute. But this is it's like a stone color, but I'll show you. I've got them all in my office. Then we've got the one that I'm wearing right now, the new it feels like the Swiftie version of I Have Questions with the custom dyed pulls, but this is our graffiti I Have Questions hoodie. It also says Law Nerd Love on the sleeve. I love it. I love it. I love it. So this is the one that has some color variations just because of availability. Don't worry, this is not the last time we are going to use this color purple. I'm obsessed. You are obsessed. We are obsessed. All of the obsessed. The Law Nerds Rock hoodie has the unicorn on the front with the purple. I love it. It is so soft. And then this is what it says on the back. It's got the Law Nerds Rock that you see on my hat. And then it also says Law Nerd on the sleeve. I'm going to show you that. So let's see. So let us go through the rest of it. This is a pin. This is a limited edition Law Nerd pin. We are trying to make sure that things do not sell out. But we do have a limited amount of the pins. So this is the pin in IRL. Look at how gorgeous. Thank you everybody for the feedback on, I wasn't sure if the pin was a rectangle. No, there it is. So that is the pin. I will show it to you. I've got it in my office. It is so good. The pictures are so good, but that is our pin. I'll show it to you compared to a quarter. It's a little bit bigger than a quarter size pin. We've got a new tote. I love this tote. The handles are lavender. I will show you that in a second. So it's good. It's good. Sarah Beth asked, is the Law Nerds Rock hoodie a slim fit? It's not really a slim fit. It shows slimmer in the photos, but it is not a slim fit. The photo mock-ups came in a little weird, but I'm going to hold it up and show you. The Straight Facts stationery notebook set does have stickers in it. I'm going to tell you a little bit about the Facts pen carrier. It's got a little bit of give to it. And I love that because you can fill it with all your favorite things, but there are stickers in here as well. So the first sheet does have stickers. And then we've got the two new hats with our kind of Law Nerd Love tattoo design and our Law Nerds Rock hat. And you can see that the back of those clasps are really rounded. Absolutely fantastic. Love, 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 love. Yeah, Megalina, go ahead and end the poll. I'm going to show you some of this stuff IRL right here, you guys, because I have it in my hot little hands. So our Law Nerd Love with the patch, it is a physical patch. It is so good, but it is a lovely, lovely hoodie. What size am I holding? Because I have this hoodie in a couple different sizes. This is the large. It is a comfy, cozy hoodie, and the patch on the sleeve is absolutely a delight. But yes, a physical patch on the sleeve. And then we've got the little Law Nerd Love, our new shop logo, and our new love for the Law Nerds down on the sleeve. Then we have our gray hoodie. Again, It photographed a little bit different because it is not a drop sleeve or not a drop shoulder, but it does not fit particularly slim. I found it to be incredibly comfortable. So other than the sleeve being a different shoulder, it did not feel like a slim cut to me. I am not a slim cut kind of a girl. Emily, do you buy things that you want to wear? Yes. Yes. And then this one that I'm holding is an XL. So it is fantastic. It's got our unicorn on it because this is a unicorn community. We've got our Lawnerd, and then we've got our beautiful Lawnerd's Rock with our, we gotta have the nails in our Lawnerd's Rock. So we've got our Lawnerd's Rock. The patch is, let me see. The patch is sewn on, and the patch itself is printed onto the patch. Nope. Yes. Is that embroidered? I don't know how to describe it. It is sewn on. I don't know how to describe the patch. It is a lovely and vibrant patch. So it's gorgeous. But Chris can answer because Chris knows more of the ins and outs than I do. So, all right, let us go forward. Sizette, why did you choose EDB 2024? Because this was the year that we were debuting Lawnerd Shop 2024. I didn't want to put my birth year on it. This is this year. This is our vibe. So even though we are at the end of the year, this is our vibe. So we will do a Lawnerd's Established at some point. We'll go back to our first Lawnerd stream. I also didn't want to put Lawnerd's Established 2020. It just didn't feel right. So because the year of this year is our Lawnerd, but we're also doing some things that are trial specific in the coming launches. So, all right. Thank you, Chris. Chris said the patch is woven. Thank you, Chris. You have the right words. Emily has not slept. We've got our Lawnerd pin. I'm going to pull this out so you guys can see it. Sorry for the unboxing. Sorry for the unboxing. So it is our little Lawnerd enameled pin. I love it so much. So that is our pin. I'm going to put it on my bag, but I love it. So for those of you asking about shirts, don't worry. We have launches to come. Octo's like, what is sleep? Right? So yay for our little Lawnerd pin. A lot of you have asked for pins. These are limited edition. So these are the first of our Lawnerd pins. We have plans for you. Do not worry. There are plans. There are plans for you, Lawnards. There are plans. All right. We've got our Lawnerd tote. A lot of you have asked for bags for our wheelie community. These are expandable, and it is my anticipation and deepest hope that they will fit very well onto a wide variety of modes of transportation. That is my hope and my goal. So that is there. It is a perfect, for me, it is a perfect size because I'm always needing an extra bag to throw into my car. My NYC friends are like, yes, please. We need a bag for literally everything. We need a bag for literally all of the things. For those of you that wanted a size comparison, hold on. I should have done this, but I see it in the chat now. Give me 1 second. I'm going to grab my computer. Why? Because we need to visualize. I hear you, Lawnards. Hold on. I will show you. Emily, you're spilling all the tea. Yes, all of the tea. I put in this, when I go places with my kiddos, I put my Remarkable in there and my snacks in my water bottle. But Lawnerd laptop, Lawnerd tote, and you are laptopped top to bottom. Laptopped top to bottom. So that is the laptop, but I keep my Remarkable and stuff in it. Then, Emily, put things down in a normal way. I can't at all. All right, we've got our pen pouch with your facts. It is corduroy, and it does have a little bit of give, which I love, but also the corduroy is so soft. The lavender is so good. It does not show on the website nearly as well as it does here. The notebook is soft touch, which I also love. And then we've got all of our Lawnard stickers in the front page. I love it. I love it. I love it. The tote does not have a zip. It is a tote. It does not have a zip. And then we've got the Lawnard pens. My teen has already stolen a pack of these because they write so smoothly. But the pens say, I have questions, facts, and receipts. Because, Lawnards take notes. And I have questions. Look, man, if you want to rep Lawnard at a team meeting without really having a pen that says WTF, the I have questions is the perfect meeting pen. It's just how to share your displeasure without sharing your displeasure. I have questions. Just roll in with your I have questions pen. So that, and then we have our Lawnard hat with the patch. It is, the patch does not take up too much space, so it still fits nicely on the head. I love a dad hat. The caps are a touch deeper than our previous caps, which was feedback we had gotten not just from internally Team Baker, but from a lot of people who are like, can we have just a little bit deeper cap? We do. It still fits lovely on my head, which is not huge, but we also have lots of room, and it is that beautiful rounded clasp in the back so it won't grab your hair. And look at the stitching on the inside. Oh, it will not irritate your forehead. So I was worried about a patch. I was like, it needs to be soft. It absolutely is. It absolutely is. So with all of that, there is something I have not told you that I need to tell you. So for all of you that have ordered, this applies to you already. For all of you that have not ordered, this may apply to you. This may apply to you. But a million years ago, we had been working on a special Lawnard project. That project never launched. Why? That's a story for another day. But there are items from that project that we never sold. And we are including those while supplies last. And when I say while supplies last, I mean while supplies last in the first orders. So if you have already ordered, you are getting a gift with purchase. If you are ordering now, I imagine you will be getting a gift with purchase through today. And I will keep an eye on the shop. But there are some things in there that are unexpected. I am not going to spoil the surprise. But one of the things included in there is the Squishy Gavel 2.0. The EDB labeled Squishy Gavel will be in the gift with purchase for the first people at our shop. So there are other things in there that have been requested that have never launched. So the gift with purchase will be in your bags. I am not going to tell you everything that's in there. I know surprises are hard to wait for, but it will be fun. So those of you that have been around for a minute will see things in the gift with purchase and be like, oh my God, I remember when we were talking about doing that. So we have talked about some of the things that are in the gift with purchase, but the Squishy Gavel that we did a Squishy Gavel 1.0 and we did a Squishy Gavel 2.0. So this is the Squishy Gavel 2.0. It does not squeak. Kiwi said, does it squeak? No, because I use it on stream. So no, it doesn't. So there is that is what there is. Mike, I don't know what you mean by a fitted hat. Because these are adjustable. I'm not sure what you mean by a fitted hat. I need more details, but my brain is tired. Let's see. Victoria said, can we still purchase original merchandise? Not at the moment because we have switched distribution. There will be launches of additional product down the road. For now, this is what is in the Lawnard shop. That's why we did a shop is closing over the last few weeks, because the old shop was closing. So this is what is available on the shop. We have launches coming. There is stuff here that will sell out. I am hoping not today. We tried to order enough so that you guys weren't forced to buy things. Like, oh my God, do we have to buy it today? It is our goal that stuff does not sell out immediately, but the pins are limited edition. They will not be restocked, and we will go from there. So that is where we're at, but we will absolutely have the squishy gavel. So this is our first. When we have, or if we have stock issues, we will be restocking things. The pins, we cannot restock. The pins are limited. So with that, Law Nerds, we are going to get into all of the things. Team Baker is in the chat. And so we're going to get into some of the law, and Team Baker will update me on how we're doing with the shop and how we're doing with the limited gifts. So we will keep you in the loop. We will keep you in the loop. So Kel said, will the fax hat be back? At some point, but it will have the different physical hat. So yes, at some point the fax hat will be back. Let's see. Let us continue, Law Nerds. So we have lots coming for you with Law Nerd Shop 2.0, and Team Baker will be keeping me in the loop in the background. So do not despair. For anyone who has shipping questions, you can put stuff in your cart and see what the shipping costs are internationally. Everything is shipping from the US. And there is a list on our website of countries where we cannot ship at the moment. We are always working on accommodating international. It is surprisingly more complicated than, well, I'm sure everyone who's ever shipped a physical products understands, but it is surprisingly more complicated than I would have thought. So, all right, you guys ready? Let us go. All right. I know all of you are like, I ordered, I can't wait for it to arrive. I know. So we are using a proprietary shipping company. So we are shipping from the US. So people are asking me to stand and show my hoodie. Law Nerds. Sure I will. Hold on. I'm Emily. I'm also in my slippers. The members know what my slippers look like. Don't ask how. But this is my I have questions hoodie. Look, this is the XL on me. It is a generous XL. And that is the Law Nerd love on the sleeve. So that is our I have questions. All right. You ready? Let us get rolling. Let's talk about law, and then we will answer. Team Baker's in the chat. So they will be answering questions. For those of you asking, will the pens be available separately? Not in this launch. Christina asked about the sizes switching colors. I talked about it a little at the beginning of stream. It was a frustration with manufacture that we had because it is not as easy to source. And instead of not including the size range that we wanted, we had to switch which hoodie manufacturer we used. Those are very akin to the hoodies that we used in the shop previously. So if you have a previous hoodie, those are going to be same. But when I said the range of colors that we wanted was not always available, these are some of the frustrations we run into. They are beautiful, and they are that thick quality that you are used to. They are that thicker hoodie. So if you've ever purchased one of the Law Nerd hoodies before, they are the same. The hoodies in the up to 2X are just a touch thinner of a hoodie, and they are lovely. So, all right. Are you guys ready to roll? I know it's exciting. It is a whole new process. Thank you guys for kicking the wheels and breaking all of the things. Sweet and salty zip ups are in future launches. So Laura asked, will there be an international shop? There is stuff that ships internationally. We are working on what it looks like to ship more broadly internationally. It is not an easy problem to solve, but it is a problem we have been actively working out solutions for. So do not worry. All right, let's get to the law. Chat, you ready? Thank you guys. Thank you for your excitement about the shop. I'm excited. I'm excited for you guys to get everything that's in your gift with purchase. I'm so excited. 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 All right. Let us swoop. Oh, I have to pull up the law. Emily, stop looking at the law nerd shop. I know. We have to switch from something I'm really excited to talk about to, we're going to talk about Diddy first because there was so much going on in Idaho. Y'all, the amount of stuff going on in Idaho. There's a lot else going on in the law. It's going to go into the quick bits because otherwise we'd be streaming for 15 hours today. And I literally can't. Emily is still trying not to be sick. So we've got a bunch of stuff in the Diddy case. Let me pull up our first document. Why don't you want to copy and paste? Okay, that's cute. That's cute. Let's not do all of that. Let's just, can you go into the screen where you need to go? Even the Diddy documents are fuckery today. Come on. Everything's like, no, let's keep talking about clothes. I know. I want to keep talking about clothes too. Octo said, we're not out of bonus packs yet. Oh, good. Our gift with purchase is still available. Yay. All right, y'all. Let us swoop and let us get going. Yay, law nerds. All right. As I say, yay, we got to talk about Diddy. What did Diddy do now? What did Diddy do now? Let me tell you what Diddy did now. Diddy's lawyers are still fighting over what we talked about previously. No, what are you doing, Google Docs? Stop, just calm down. Google Docs is like, I want a hoodie. So, if you did not watch yesterday's podcast, I'm going to try to give you a summary of yesterday's podcast the best that I can. So if you did watch yesterday's podcast, you are ahead of the curve. Pop a 1 in the chat if you already saw or listened to the podcast from yesterday. Diddy made another motion for bail. So Diddy's attorneys are going to continue to try it. Diddy's like, let me out of prison. Jail. Technically, he's not in prison. Let me out of custody. Diddy's like, let me out. Let me out, bitches. The prosecution is like, ugh, please. First, the prosecution argued, you have shown nothing new to reopen this question. Like, you don't get to reopen the question of bail. We saw this argument in the Corey Richins case. In the bail arguments, you saw Corey Richins' attorneys saying this is a change of circumstance, so we can reopen the question of bail. In that case, it was the changing of the potential penalty, and the judge said, yes, I think that's enough to change the circumstances to look at the bail. You can't just ask for the bail to change. You can't just come in and be like, excuse me, you said no, you guys, you can't just do it like your kid. Hey, I know you told me no, but I figured if I asked again 9,822 times that you would eventually say yes. The court is not having it. You can't just ask again because, well, you said no before, but maybe you'll change your mind now. There has to be a reason. The court is saying that, or the prosecution is saying that there's not a reason to reopen this question now. The defense is saying, yes, there is. There is a reason to reopen it now. There's a reason to reopen it now because we learned new things. And we learned new things from the discovery from the prosecutors. And the prosecutors are like, please. That's not the truth. So Diddy and the prosecutors are fighting over bail. In part of the prosecution's answer, they spill all of the tea about Diddy's notebook. No, it is not the new Law Nerd notebook. He could never. Custody would also be like, those stickers look like contraband. We're not doing it. And I'd be like, but they're just stickers. They're not Crest White strips. That's a deep callback to the Corey Richins case. But Diddy apparently had a notebook. The name of the notebook was redacted out of everywhere except for the footnote. So we now know it's the to-do notebook. And we heard about that in the court hearing as well. And if we want to go over the court hearing a little bit, we can. It was covered really well on Twitter. So the prosecution brought in information from Diddy's to-do notebook. The way they got that information is that there had been a sweep of the MDC by law enforcement related to something else. Diddy's lawyers are like, this was a pretext. You made up a fake reason to search his jail cell. And they're like, no, we didn't. There are complaints about MDC. It seems like I speculated that they're dealing with contraband issues because they searched multiple housing units in the jail, but they also searched some offsite providers connected with the jail. So it seemed like they had a operation set. Whether it's pretext or not is kind of, six of one, half dozen of the other, because they don't need a reason because you're in jail. And Diddy had already been using other people's phone codes. You guys heard about Alec Murdaugh doing this, had been using other people's phone codes to make phone calls to people not on his approved list, thinking that it wouldn't be tracked. We are living in a digital age where those things aren't hard to track. I'm not going to talk more about it. We don't need to help people crime better. But if you don't think, just for anybody, if you do not think that the government can find you making a call when you are calling from a jail facility, that's hilarious. If you use another inmate's phone code number, you're not even really slowing down the process that much. You're just getting yourself in further trouble because it looks like you're up to fuckery. But custody's going to find you on your phone, not to mention they had tapped Diddy's phones well before any of this. So Diddy was using three-way calling. Also, you can't call up a known number or a number on your approved list and then be like, yo, I need you to call so-and-so, and then have that person initiate the call to the other person. You think they're not going to track that too? Boo. Come now. If anything, you slow them down minimally. So Diddy had been using other inmates' phone numbers. He'd been using three-way calling. He had been using a service that is disallowed in custody to have communications. The prosecution said he's trying to mask his communications so they don't find it. And it seemed that he was also offering or asking people on the other end of the phone. I'm sure they have somebody just assigned to listening to Diddy's phone calls, but they had listened to the fact that Diddy was offering payment to people's books and was putting money on people's books for letting him use their in custody code. So Diddy was already breaking the rules of MDC. So did they need a reason to check his cell? No. The defense is arguing it's a pretext. However, a bunch of the stuff in his cell was photographed. This is what the prosecution said in their motion regarding bail. And in the bail motion, they argued that Diddy had paid someone to make or offered to pay someone to make an Instagram post that refuted statements in one of the civil lawsuits. Some of you who have been following the case closely know what Instagram post we are talking about, but had made an Instagram post that was like, that wasn't my experience, to dispute what was coming up in one of the more recent civil lawsuits and offering payment there. So the prosecution was saying, if Diddy is allowed out, we are even more concerned about witness tampering, witness intimidation, intimidating victims, all. So then the defense came forward and said, excuse me, the things that you have taken, photographed, all the rest of it is attorney-client privilege, and how dare you? So then the judge said, y'all get into court tomorrow. Get into court tomorrow. Get into court tomorrow. I need, just come to court immediately. All of you come into court immediately. So that's where we are. We are now talking about the get into court immediately regarding things in Diddy's jail cell that may or may not have been attorney-client privilege. Now, you guys know how this goes. Where else did we see this fight? I feel like we're in law school. In what other case did we see defense attorneys arguing that things taken from a defendant's jail cell were attorney-client privilege information? Corey Richins. Exactly. How well did that go? What did the court rule in that case? The court was like, nope, those are not privilege. Some of the things weren't even seen by the prosecution that weren't privileged. The prosecution here said, look, the things we were concerned about went to a filter team. The way I'm so mad they don't call it a taint team in the federal courts. Hey, it went to the filter team. And the filter team was deciding what was attorney-client privilege. And that's where we are stepping into the rest of this, because the 19th and the 20th, a whole bunch more shit was filed. Because of course it was. All right, let us go to the Diddy motion of it all and get through what the defense had to say after the hearing. During the hearing, the prosecution said, we didn't take anything from Diddy's cell. Pictures were taken. Some of the pictures went to the taint team. Some of that was redacted and then given to us. Diddy's lawyers were like, how do you know what's attorney-client privileged? And we talked to him about these things, and then he makes a to-do list. So these are defense strategy and defense witnesses, and how dare you? And that's where we're coming in to all of this. So let's talk about the letter to the court on November 19th. The defense writes this letter in advance of today's hearing and in response to the government's letter of November 18th, which was covered on the podcast. The government's letter only reinforces the fact that the government has committed an egregious, willful, harmful breach of attorney-client privilege and has become privy to the defendants and defense counsel trial strategy, including areas of expert testimony, witness strategy, and other confidential matters. Materials to be provided to defense counsel. Defense counsel has been provided with 19 pages of materials seized from Mr. Combs' locker at MDC. I don't know if they were seized or not. The prosecution said that photos were taken and that the physical items weren't taken. According to the government, these 19 pages were given to and are in the possession of the trial team, which has already started using these privileged materials to its advantage, including its opposition to bail. Yeah, the government's like, hey, we're really worried about witness intimidation because, like, he's strategizing a PR campaign on the phones, and he's offering to pay people who could be witnesses to post things beneficial to him. We have concerns. And the defense is like, that's all privileged. You can't take it and use it against us. These include intact pages from 2 different legal pads. So the defense is saying, you took shit. The prosecution said, no, we just took pictures. Pages of an address book, a ripped out, folded over page of a 3rd legal pad, a ripped out page of another legal pad, and a ripped out page of yet a different legal pad. What? The first page from a folded over intact legal pad, footnote 1. In its letter from yesterday, the government refers repeatedly to a notebook. The documents provided to counsel do not show any notebook. They show a number of legal pads. Okay. The first page from a folded over intact legal pad. The second page is a copy of the first page, but is enlarged. Pages 3 through 11 are pages of an address book. The 12th page appears to be the first page of a second legal pad. What the fuck? Somebody get the string. Somebody get the string. The 12th page appears to be the first page of a second legal pad. It feels like a clue to an online game. The 13th page is a second second photograph of the same page. Of that same page, what are we referring to? Is that the first page of the second legal pad? Or is that the first page from a folded over legal pad? It's easier for the court because they can see all the pages. Or a different Xerox copy of the same photograph. Look at this photograph. Your Honor, the government has photographed the same photograph and then they made a Xerox of the photograph. And then they faxed it to us. Pages 14, 15, and 16 appear to be folded over pages of the same intact legal pad. Page 17 is a single folded piece of paper removed from yet another legal pad. This legal pad has 3 vertical lines down the left side, whereas the other legal pad has 1 vertical line down the left side. Different pad, different paper. Page 18 is a single sheet of paper ripped out of the legal pad. Which legal pad? Page 19 appears to be a ripped out single sheet of paper from a 4th legal pad. The legal pad has no vertical line on the left side. Also, the legal pad has 21 lines, whereas the first legal pad has 35 lines. Your Honor, they are totally different legal pads. I mean, okay, they're different legal pads. Can we number them? Based only on the materials provided, it appears that the investigator took photos of more than one notebook and address book as represented by the government's November 18th letter. Rather, he appears to have taken photographs of the pages of several legal pads, both pages that were intact in the legal pad as well as loose pages. Okay, here's the thing though. The government would have only been provided what the filter team gave them. So the government didn't take any of this stuff out of the jail, and the government didn't take any of the photos. So the photos were taken by an investigator and then given to a filter team, and then the filter team determined what got turned over to the prosecution. It bears reminding that these clear written statements of the defendant were not provided to the defense as part of the government's discovery or Brady obligations. If it were not for the fact that the government used portions of these privileged materials in an effort to hold Mr. Combs in jail, we still would never have even known about them, because the government keeps saying this is part of an ongoing investigation, because the government keeps saying there is still an ongoing grand jury, and we know there is an ongoing grand jury. The notes are obviously privileged. I love that we've gotten to the obvi argument. Your Honor, obviously privileged. Writing legal on it, by the way, does not make it privileged. Writing legal on it doesn't mean that the government's not going to take it, or that the filter team's not going to look into it. Of the 19 pages provided to counsel, 11 pages are Mr. Combs' notes to and with his lawyers. These notes reflect actual conversations with his attorneys concerning aspects of the trial preparation and his efforts to be released on bail. Remember, the prosecution said that there was a legal, manila envelope that was not searched. Footnote 2. Attached as Appendix A is a sealed ex parte affirmation of Tenny Gregarios? No, Garagos? Why is everyone named Garagos? Of Tenny Garagos explaining the context of these notes. The reason it's ex parte is because the defense is telling the court, Your Honor, this is why we know it's attorney-client, but we don't want to and cannot tell the prosecution because it goes to defense strategy. That's a proper use of ex parte. Your Honor, we're telling you this is defense strategy and this is why we know it's privileged. We don't want to give the government any more context to understand the notes that they already have. Attached as Appendix A is a sealed ex parte affirmation of a lawyer explaining the context of the notes. We respectfully request that this affirmation be filed under seal and ex parte to prevent any further disclosure of privileged information. To be clear, they love that phrase. They love that phrase. To be clear, Mr. Combs never waived privilege over these materials, and as soon as the defense team learned of the disclosure in the government filing, requested their return and destruction. Chad is saying that Tenny is Mark Garagos' daughter. Well, that's why everybody's named Garagos. Same family. I didn't know that. Not Gyarados, chat. Not like the Pokemon. God. Lawyers, got to catch them all. Okay. The notes refer to defense counsel by name, include discussion of defense experts and witnesses, discuss cross-examination and credibility of witnesses, and overall defense strategy. Mr. Combs' handwritten notes cover legal strategy are now in the hands of the trial prosecutors who hope to take advantage of the breach they committed to better prepare for the May 2025 trial, bring new charges, and argue for Combs' detention. Well, they definitely want to bring new charges. Combs keeps his legal materials in his locker. His notes are in the form of a number of legal pads, several of which the government has photographed, as well as loose pieces of paper on which he makes notes. Me, when I went to the Combs detention hearing in federal court, not realizing I would be in court that day. And so I was grabbing every tiny bedside notepad I could find from the hotel, and then ended up writing on paper towels from the bathroom anyway, because I ran out of paper because I had not planned on being in court that day, and you can't take in digital devices, and I did not have a notepad. Yes, that is true. Yes, I was writing on paper towels. It worked just fine. Paper. As well as loose pieces of paper on which he has notes. On top of his legal pads and notes, he has a folder marked legal. This is to put anyone on notice that everything along with the folder marked legal is exactly what it says, legal. They're going to be like, but it's not in the folder. Legal attorney-client materials that he brings to his meetings with his lawyers to prepare his investigative and his trial strategy. Footnote 3, Combs' legal counsel previously attempted to provide him with Redwell folders to assist in his organizing his legal papers, but those materials were rejected by MDC. The Redwell folders are good. When he finishes a meeting with the lawyers, he brings his legal materials back to the locker where they are kept with the clear warning written on the folder that his materials are legal materials. So when Investigator 1, who we will get to in a minute, the anticipation is building. So when Investigator 1, we'll get to him or her, we'll get to them in a minute, saw a manila folder marked legal, this was his cue that all the legal pads and loose pages of the legal pads that accompanied it were legal materials. That's not how that works in custody, though. If the warning legal wasn't enough, the notes are obviously legal materials that he discusses with his lawyers. They repeatedly refer to his lawyers by name. Investigator 1 doesn't know who the fuck his lawyers are. Tom told me. And they repeatedly refer to his lawyers by name. On the 14th page, he writes about redacted. He wrote that redacted. It's hard to imagine a more self-evidently privileged conversation than a trial lawyer telling a defendant all about redacted. If this case weren't so serious, and it is, and I don't want to make light of the things that are being alleged in this case, but I can see a world where, how many of you grew up in a day and age where you didn't have cell phones? And there was a game that you could play, my family did it on road trips and planes, where you would fill in the blanks of things. So when I'm thinking of the redaction Mad Libs in my brain, it's because I grew up in the Stone Ages and used to play Mad Libs with my family. And so when I see he wrote that, it's hard to imagine more self-evidently privileged conversation than telling a trial lawyer about my brain immediately goes to Mad Libs. And I'm sorry, because my brain won't stop because of the way that they redacted it mid-sentence. It feels like legal Mad Libs. On that same page, Mr. Combs wrote about his fluffy llama. So this is a heartland trial strategy. I don't even know what they mean by heartland in this context because my brain has run so far away to the Mad Libs. This is a heartland trial strategy being expressed in detail in notes of conversations between Combs and his lawyers. The fact that a government investigator, government taint team, thank you to the defense. Wait, the defense doesn't really get applause very much from us. Their snappy writing sometimes gets applause, sometimes gets an eye roll, but here's the applause. Well done, defense. The defense is like, fuck a filter team. That's a taint team. So the fact that the government investigator, I mean, it's not really a government investigator necessarily. I mean, I guess they're all employed by the government, but still. The government investigator, the taint team, and the entire prosecution team viewed this and still believed they could keep the notes and use it against Mr. Combs is unfathomable. The government took notes directed to his lawyers to pay off witnesses. No, Emily, that's not what it says. In preparation for trial. And then used those notes as a basis for claiming that he was attempting to tamper with witnesses is astonishing. That's probably right. As discussed above, the notes are replete with discussions of legal strategy between Combs and his lawyers, all of which should have been obvious to everyone who looked at the notes. Investigator 1, the taint team, and the trial team. Your Honor! Obviously, this is a problem. That the government did not inform defense counsel that it had Mr. Combs' notes in evidence. No, my brain is now jumbling the words on its own. That the government did not inform defense counsel that it had Mr. Combs' notes is evidence that the government is acting willfully. Well, they've got an ongoing investigation. As noted, the government did not produce these notes of defendants' own statements to the defense as part of its discovery obligations. The opening paragraphs of Federal Rule of Criminal Procedure 16 require the government to disclose defendants' written or recorded statement to the defense. The prosecution is trying to get around this a little bit. I don't know if that's going to work. The government is saying, but we have an ongoing investigation. The court, I imagine, is going to say, but you also have a prosecution. We've passed from investigation to prosecution. You have an ongoing prosecution. One would think this would be especially urgent when the written statements at issue are in the form of the defendant's own handwritten notes that were taken from his jail cell and which reflect specific conversations with counsel, but the government did not produce those in discovery or these in discovery. Nor did the government's taint team establish for this precise type of situation, contact counsel. Well, they're not going to do that in an ongoing investigation. Contact counsel and advise counsel that it was in possession of defendant's handwritten notes. As part of the hearing and to determine what sanction is appropriate for this egregious, self-evident privilege breach, defense counsel wants to know exactly what the fuck the government was thinking. No, that's not what they said. Exactly how the decision was made. They said it in legal. And by who? To not contact defense counsel when the United States Attorney's Office came into possession. And this came up in the hearing. The government's explanation of how it took these notes is riddled with self-contradiction and lacks common sense. The government referred to Investigator 1, whose role in these events is as mysterious as it is contradictory. What, are we writing a crime novel? The government referred to Investigator 1, whose role in these events is as mysterious as it is contradictory. Tell us more about that, Bill. Well, thank you, Jane. The government states that Investigator 1 was assigned by the Bureau of Prisons to participate in a sweep and that he is not part of the government's investigation of the defendant yet. The government also states that Investigator 1 has continuously monitored the defendant's communications. The government also states that it had sent jury subpoenas and document requests to the Bureau of Prisons for the defendant's monitored communications. The letter is silent as to which Bureau of prisons officers or officials and prosecutors work with in connection to ensure its efforts to secure defendants' monitored communications. How weird. But it would appear that prosecutors work with, among others, Investigator 1. Full on contradiction. I know. Though it's just as likely that Investigator 1, footnote from the narrator, it's just as likely from Investigator 1 that Investigator 1 does work with the Bureau of Prisons and is set to monitor defendant because he's so prolific on the motherfucking phone. Under these circumstances, the hearing should encompass what connection exists between the prosecution team and Investigator 1. How y'all know each other? What's tea? Second, Your Honor, the government writes that the BOP sweep was pre-planned. Sure. Not in response to any particular threat or intelligence, and did not target Combs. No, it seems like they have a big issue with people smuggling shit into MDC is what it seems like, to be frank. They go on. However, the government also writes that there was nothing improper about Investigator 1 taking photographs because Investigator 1, who had reviewed the defendant's calls and emails, was entirely justified in inspecting the defendant's assigned bunk to recover additional evidence. Yeah, because defendant keeps breaking the rules in custody and has no reasonable expectation of privacy because he's in jail. So there is that. So they are justified in searching. Whether they're justified in turning it over to the prosecution team is a bit different. Sweet and Salty asked, Emily, did you ever slip up and swear in court? No. There were no slip-ups out of my mouth. Out of my cell phone, yes. No slip-ups out of my mouth. However, I was very much of the drama level of Alan Jackson when the opportunity presented itself. Can't even say that I wasn't of the same level of drama, glee, and delight as Alan Jackson getting to say fuck in court. So let's get back to what the government is doing. Let's see. The government's position is immediately self-contradictory because the review of a particular inmate's cells and emails is intelligence. And because acting on that intelligence in order to conduct a particular search is targeting Mr. Combs. They decided to search this housing unit because of other shit. The government's own letter shows that Combs was treated differently from other inmates and that the search of his locker and removal of his notes was based specifically on the intelligence that Investigator 1 developed from listening to his calls and reading his emails. That's not what they said. What they said was, we knew that this was not privileged because this investigator was familiar with Combs and his case. That's what the government was trying to get at. I'm sure they searched every inmate, including SBF. I'm sure they searched everyone in this housing unit because they were looking for contraband, which they do. Third, the BOP sweep was purportedly related to removing contraband at the facility. Yeah, somebody's sneaking in Crest White strips or something else. Removing contraband from the facility. The release goes on to state, because there was a press release about this, the combined operation identified and confiscated a number of electronic devices, drugs, and associated paraphernalia, and homemade weapons. No Crest White strips. Yet Investigator 1 apparently used this sweep as pretext to conduct a targeted seizure of Mr. Combs' handwritten notes about conversations with his lawyers. Okay. Tellingly, the issue for me is not that they searched. The issue for me is not that they photographed. The issue for me is, where do we go from the filter team to the prosecution team? And is there anything privileged in there? Taking shit, photographing shit, none of this is an issue for me. How it went from the filter team to the prosecution could be an issue. We'll see. Tellingly, Investigator 1 did not report that he had identified and confiscated Sean Combs's notes of conversations with his lawyers to supervisors of the multi-agency law enforcement operation. He went straight to the prosecution team. I think he went to the filter team, or he told the prosecution team and they said, go to the filter team. Okay. The prosecutors have taken the position that the identification and photographing of Combs's handwritten notes were merely a part of a multi-agency sweep to rid the MDC of drugs, electronics, and homemade weapons. There are ways of proving such a contention. We can call Investigator 1 to the stand at a factual hearing. A hearing should encompass what else Investigator 1 told the prosecution team and the legal materials he rifled through. You saw how this went in the Richens case. Did Investigator 1 photograph any notes aside from the 19 pages defense counsel was provided yesterday? What, if any, direction did Investigator 1 have from the agents conducting the pre-planned law enforcement initiative? Or was he taking direction from someplace else? The crime scene spoke to him, counsel. The jail spoke to him. The bottom line is that no multi-agency law enforcement initiative justified rifling through Mr. Combs's personal handwritten notes. Based on what? The issue is what got filtered and what got turned over. Not that the search happened for me, but the drama level is just 10 out of 10. Monica said, is this a legal filing or a novella? Both. Both. Evidence shows there was a law enforcement plot to photograph Mr. Combs's notes, have the taint team not advise counsel, and use these plainly privileged materials to keep Combs in jail and to gain an unfair trial advantage. Dude, Combs is staying in jail no matter what they found or did not find. Newsflash. The law presumes he stays in custody, but now there is a plot. Does it thicken? Before Friday evening at 11:30 p.m., defense counsel knew none of this. It was not until the government attached 2 pages of the defendant's handwritten notes, well, now we know what was redacted, 2 pages of the defendant's handwritten notes to a letter to keep him in prison, that defense counsel learned for the first time. Over 2 weeks earlier, Mr. Combs's notes were photographed and provided to the U.S. attorneys. In the last 4 days, several things have become clear. I knew 3 things at once. First, Edward was a vampire. Second, crap, I'm not going to get this right. There was some part of him, and I don't know how large or small that part is, that wanted to suck my blood. And third, I was in love with him. I think we're close. I think we got close. First, Edward is a vampire. No, first, Investigator 1, who had been monitoring Mr. Combs's calls and emails and was absolutely targeting him, seized upon an opportunity to search his cell. I thought he searched his locker. Where's the locker? He knew that there was a completely unrelated multi-agency law enforcement measure planned for October 28th, 2024. One related to ridding the MDC of weapons, drugs, and cell phones that had nothing to do with an inmate's notes of conversations with his lawyers. You can't hide drugs in a notebook? Can't hide a shank in a legal pad? Sure the fuck you can. Cell phone would be a little bit harder. But yeah, sure you can. Sure you can. Because he had been monitoring Combs's conversations, he conducted a warrantless search. Sir, he's in jail. Okay. He conducted a warrantless search of Mr. Combs's papers. You don't need a warrant. Not looking for weapons, drugs, or cell phones, but for what Combs and his lawyers were discussing and what Combs's trial strategy would be. Sir, we know what the fuck your trial strategy is. Every single hearing, you come into the hearing, every single hearing, you come into the hearing and say, this was a consensual relationship. It was complicated. It's not human trafficking. It was love. The gaslight and blame Cassie is the entire trial strategy thus far. It's not a secret. It's in every single filing. It's in every single argument in court. It's clear what is Sean Combs's defense team going to do? They're going to call everyone a liar. They're going to say that everyone consented. They're going to say that everyone wanted a piece of Diddy. They're going to say that everyone just wants money. We know what they're going to say. They've been screaming it from the rooftops. In that first hearing, he said, this witness has 30 million reasons to lie. We know what your trial strategy is. It's not subtle. Blame everybody except Sean Combs. Sean Combs was just taken advantage of because he was rich and powerful. Everyone just wanted a piece of him. All right. So they conducted a warrantless search in custody where you have no expectation of privacy. Not looking for weapons, drugs, or cell phones, but to discuss his trial strategy. Okay. So he photographed pages where the defendant discussed what types of expert witnesses to call, where he identified witnesses, where he discussed his thoughts about the credibility of the most important witnesses. Well, we know what he thinks about the credibility of the witnesses, don't we? However, was he discussing his thoughts about the credibility of witnesses, or was he discussing a strategy to intimidate the witnesses, is what the government's going to argue. But he wrote out his thoughts about the credibility of the most important witnesses in this case and other things revealing the defense trial strategy. Once he photographed these pages, he returned the legal pads and other documents to their original location so defendant would have no idea his handwritten notes had been taken in this manner. Then he called trial prosecutors in this case to aid them in their investigation. And because he knew the information that would help them, defendant's trial strategy laid out in his handwritten notes. Whether he revealed to the prosecution team even more privileged information than what is contained in the notes remains to be seen. Next, at the prosecution team direction, he sent the notes to the U.S. Attorney's Office, to the taint team, whose sole purpose is to ensure that attorney-client privilege material is not given to the prosecution team. At no point does the taint team contact defense counsel. Right. The filter team's not going to contact defense counsel. There's an ongoing investigation, apparently for witness intimidation. At no point does the taint team ask defense counsel if anything in these handwritten notes is potentially privileged. Because what would the answer be? We saw Corey Richard's attorney make the argument that the entire Walk the Dog letter came from a novel. And it was a fictionalized account of somebody trapped in jail in Mexico. And that was all attorney-client. Well, it's either a novel or it's attorney-client privileged information, but what the fuck, it's not, is both. So we've seen defense teams really stretch to find what's privileged. This whole novel, Your Honor, is our defense strategy. It's attorney-client privileged, even though it's not real. It's not witness intimidation, Your Honor. It's a story. At no point does the taint team ask defense counsel if anything in these handwritten notes is potentially privileged. Given that there was an established protocol in place, it is inconceivable. This is mere oversight. Inconceivable. Similarly inconceivable is how the taint team, ostensibly trained to review privileged materials and provide the names of all defense counsel and provided with the names of all defense counsel, somehow did not see the obviously privileged nature of the notes. It's probably not obviously privileged. We can't evaluate for ourselves because we don't have the notes. These notes refer to defense counsel by name, include discussion of defense experts and witnesses, discuss cross-examination and credibility of witnesses, and overall trial strategy. The taint team even recognized that portions of the notes written on the very same page contain privileged information, yet failed to realize the privileged nature of the rest of the page. Well, if they failed to realize it, then it's not willful, is it? The fact that the prosecution team then received the notes from the taint team and likewise failed to understand what had come into their possession is just as egregious. Your Honor, I literally can't. At some point, the trial team comes into possession of 19 pages of materials. At no point does the trial team contact defense counsel to state that there are references to particular potential witnesses or to possible areas of expert testimony, or even the fact that Combs specifically writes that the fluffy llama walks alone. The trial team didn't tell defense counsel any of this for the same reason the taint team didn't tell defense counsel, and for the same reason that Investigator 1 targeted Combs and photographed these notes in the first place, because there was a plot to get attorney-client materials. And once they got them, the first thing they did was specifically use them by putting them into a bail letter to keep Combs in jail. Well, the defense has had enough. The defense has had enough. Kate Manning, this level of writing is a drama llama. So drama llamas. A fulsome hearing is required. Well, 10 out of 10 to the defense writing. I mean, there are times I think the defense is overdone. In this case, there is no lack of drama, but at this point, the writing has kept me engaged, and you've used fulsome. So 10 out of 10 on the language and the writing. Your Honor, we are so outraged. We are using fulsome. We have used egregious. We have used ostensibly. We have said inconceivable. And we have said taint 700 times. Crack. Say crack again. Crack. A fulsome hearing is required. The government's proffered explanation for how it got this information is internally inconsistent and not credible. As a result, a hearing is required. Your Honor, grant us a hearing. So that is what the defense wants. They want a hearing on the entire matter. We are going to need to go to what the court did before we even get into the court rulings. No, let's get to the court hearings, the court rulings. Let's do the rulings first. And then if we need to go to the play-by-play of the hearing, we will, because we have to get to Idaho at some point today. And right now we are stuck circling in New York. The court put a note on this. I thought, let me find it in my notes. There are so many filings. Let me see where the courts, I thought the court stamped this one. I thought that's the one I had pulled up, but I do not see it. Did I miss it? Maybe I missed it. Maybe not. Let's see. Maybe it's the next one. All right, let's get into what the court filed and we'll go from there because we need to do that. Oh, that's not helpful. Why? Can you just give me my drive, please? Streaming is dynamic. All right, let's go to the next in order. Who's out of order? You're out of order. All right, let's go to the judge's order from the 20th, yesterday. This is docket number 76 from Judge S. For the reasons stated at the hearing held on November 19th. Do we need to go through the hearing? Hold on. I'm going to just ask you guys, and then we'll go through Idaho. But this is why I need to stream 3 days a week. Do we need to Zoom? I'm going to ask if we need to Zoom through the hearing summary. Yes, no. It's not there's no court video audio. It's all recapped on social. For the reasons stated at the hearing held on November 19th, the government, with the exception of the filter team, must immediately delete the photographed notes at issue, pending the court's ruling on whether they are covered by attorney-client privilege. Oh, the court's not happy. Court's not happy. Court's like, delete it and then we'll decide. The government should confirm on or before November 21st that the notes have been deleted. Based on the government's representation that the filter team has no involvement in either the grand jury investigation or this litigation, the filter team may retain copies of the photograph notes, but may not provide them to anyone else. Ooh, the judge is mad. Briefing on defendant's application relating to the notes will follow this schedule. Defendant's brief must be filed by December 4th. Government response December 9th. Defendant's reply December 11th. The defendant's reply brief on his renewed motion for bail is now due Thursday, November 21st at noon. So now. So there's going to be a new filing, literally now. The judge is not happy. The judge is like, we need to know. All right, let's see what the court ordered in docket 77. I have no idea what the court ordered, so we're going to find out together. The judge is like, I don't like it. We're going to review it. Don't like it. Don't like it. Remy said, my brain thinks Holmes every time Emily says Combs. I know. I have been told that the way I pronounce the word Combs, the only way my mouth works, it doesn't always work well, people hear different things. Apologies. It's half the time why I call Diddy Diddy, because otherwise the comment section is like, you say Combs weird. I know I do. I don't know. We do our best. But yes, I know I do. Judge S said in his order from November 20th, in his November 19th letter to the court filed prior to the hearing that same day, the defendant stated that a government investigator took photographs of several items, including intact pages from 2 different legal pads and ripped out pages from other legal pads. I think they meant that the photos were taken of pages that were ripped out, not that the investigator ripped out the photos, given the full context. The letter also described the legal pads in detail and argued that they were privileged in part because on top of the legal pads and notes, defendant has a folder marked legal, which put anyone on notice that everything in the folder marked anything along with the folder marked legal is attorney-client material. I don't know if that's accurate. I don't know if that puts people on notice in the jail. You'd be shocked at what people do to avoid detection into the jail. Well, you probably wouldn't actually, but you know what I mean. At the November 19th hearing, defense counsel presented the court with an intact legal pad with legal written on the binding, stating that the legal label on this and other pads showed that they were clearly protected by attorney-client privilege and should not be in the government's possession. The court notes that the sealed exhibit to government's brief includes photographs of 2 intact legal pads, both taken at the time of the BOP sweep. There is no writing on the binding of either pad. Oh, shit. Oh, shit. Oh, shit. That's not good. We're gonna back up.
Bruh.
Oh, shit. I love those of you in the chat that knew this was coming and have been waiting. Becca Has Thoughts said, I've been waiting for your reaction to this. This is why I don't pre-read things before we cover it on stream. I want to experience it in real time. If any of you have watched day 3 of the Alec Baldwin trial, you know how that goes. It's so funny. I need to process, because there's times you can see people commenting on the Alec Baldwin day 3, clearly early on in the video, as if they don't know I'm watching it in real time. Not y'all, but as if they don't know I'm watching it in real time. They're like, this aged well. I'm like, did you watch to the end? Because you can see my day go from like they're throwing everything at the wall to see what sticks to, oh fucking hell, what's happening? Like, you can watch it happen in real time. It's why we react in real time. Don't worry, chat. For those of you that are like, wait, what? Don't worry. I'm going to back up and do this again. Oh, fuck. In his November 19th letter to the court, I'm rereading this whole thing again as my brain buffers. Defendant stated that a government investigator took photographs of several items, including intact pages from 2 different legal pads, and ripped out pages from other legal pads. We just read that. The letter also described the legal pads in detail and argued that they were privileged in part because on top of the legal pads and notes, defendant had a folder marked legal. That was in the prosecution's motion as well. And the prosecution's motion said the folder marked legal, or the envelope marked legal, was padded down to see if there was anything like more 3-dimensional in it that needed to be searched, but didn't open it. The defense said that that folder was put on top of the legal pads, and like anything below it somebody should have been on notice. They said it put anyone on notice that everything along with the folder marked legal is attorney-client material. At the November 19th hearing, defense counsel presented the court with an intact legal pad with legal written on the binding, stating that the legal label on this and other pads showed that they were clearly protected by attorney-client privilege and should not be in the government's possession. So I don't have a legal pad here because I hate them, but they're saying that on the top of the legal pad on the binding, it said legal across the binding on the top of the legal pad. The court notes that the sealed exhibit to government's brief includes photographs of the 2 intact legal pads taken at the time of the Bureau of Prisons sweep. There is no writing on the binding of either pad. So the defense misrepresented to the court that that had always been there. So it was written after the photos were taken. And the defense counsel is not going to convince me that they didn't clock it. You know why? I'm going to tell you why. Let's finish reading this and I'm going to tell you why. Defense counsel, there is no way they didn't clock that in the photos from the government, it did not say legal on the binding. And then they represented to the court that that had been there at the time of the search and that the government willfully took attorney-client privilege, and the government should have known it was attorney-client privilege because the fucking legal pad said legal across the top, but in the photos, it's not there. So they represented to the court that it existed at the time when the court is calling them out saying clearly it did not. Photos taken at the time indicate there is no writing on the binding of either pad. At the scheduled hearing on Friday, November 22nd, defense counsel should be prepared to give the court further context on the legal label that the court was presented with at the November 19th hearing and to address why this label doesn't appear on the photographs in the court's possession and why it wasn't addressed in defendant's submission to the court made a few hours before the November 19th hearing. Oh, fuck. You in trouble. You are in trouble with the federal court. Counsel, I'm going to need you to go ahead and explain it to me. Why you came into this court on December 19th. We got to go through the court hearing. We got to go through the hearing. You came into this court on December 19th and said, in the summary, look, Your Honor, it says legal. Anyone would have known The government willfully took attorney-client information to try to game the system. And the court said, I went back and looked at the sealed photos, and it's not there. And not only is it not there, but in your entire fucking diatribe of the novella of the government plot, it doesn't say once, not once. We read the whole fucking thing. I couldn't have planned this better because I didn't know what was in these motions. I said, we're doing this all in real time. We read the submission from the 19th. It's inconceivable, they said, that the government didn't know. And what did they cite? What did they cite? That the lawyers' names were in there. They said the lawyers' names are in there. They said that the legal folder or whatever was on top. Never once in that motion do they say, and the legal pads were marked legal. Not once in their motion did they argue it. Maddie said, would this be considered defense hiding the ball? No, this would be considered lying to the court. Because somebody wrote that on there after the fact, and then they presented it to the lawyers. The lawyers presented it to the court saying it was there. Oh, shit. Chat, I grant your motion for code red. I grant your motion for code red. Oh, tomorrow's hearing is going to be fire. Counsel, you need to come to court prepared to tell me what the fuck. Code red. We're going to code red. Law nerds, if you're new in the chat, hi, how are you? Welcome. Good to see you. Code red is a bit flashy until the music ends. So if you are flash sensitive, it will stop when the music ends, which is why I give you a heads up that we are going to code red. I love it. It is code red, but just so you know, we are giving a warning. Danger. Ooh, danger. Here's the thing. The court didn't seem happy with the prosecution. The court's like, I order you to destroy those. I'm not happy. And then the defense does this and the court goes, but you want to know what I'm really not happy about? You want to know what I'm really not happy about? You were winning and then you stepped on your own dick is what just happened. We're going to code red in 3, 2, 1. We went a little bit code red, code Death Star for the moment. Oh shit. Who does this? We got to go to the hearing. We were supposed to get to Idaho. Idaho, we'll get to you in a minute, boo-boo. You're going to wait. Idaho's got to wait. We'll be back, Idaho, I promise. I'm going to start singing Omaha in just a minute. Is it the same? No, it's not the same, but we're going to start anyway. All right, let me go find the rundown of this hearing on the Twitter real quick. Emily, wrap your head around calling it X. No, literally cannot. Let me go. I don't even, this app sometimes is just not easy. I thought I bookmarked. Yes, I did. I bookmarked it from Inner City Press. All right, let me grab this. Inner City Press goes into courtrooms. I do not know how they accomplish the incredible, like live in real time telling of what happens in court, but it's incredible. So if you use that app, I rarely say there are things on that app that are like 10 out of 10. This is 10 out of 10. And for all the hearings in New York, they did a great job with the Jen Shaw hearings as well. Let me find that hearing. Where did it go? Why can't I find it? Hold on. What is happening? I don't even understand how this app works at this moment. This is not what I had saved. Oh, I'm not logged in and therefore I can't see everything. That's strange. All right, we're going to just use my other browser for a moment and hope that it doesn't make the sound go crazy. Where is this? No. I just want the Diddy hearing. It wasn't that long ago. There was another hearing going on. I'm skipping all. Okay. Get me back to the hearing I was trying to find. Oh, where did it go? All right. You guys, once I find this, I had bookmarked it and then it disappeared. So I thought that's not how that was supposed to work. It was supposed to get me right to the thing I saved, I thought, but that doesn't seem to be going the way I thought. Okay, there we go. Yay. Everybody, I'm going to applaud myself for figuring it out. I feel, that was too loud. All right. Okay. Let us go to, nope, not there. Nope, not there either. We're going to a different screen and hoping that works well. All right, let's do this. Yay. Streaming is dynamic. All right, we've been able to do this in reader mode. This I actually do appreciate. So let's go to Inner City Press. Do a play-by-play of this hearing. Because, oh my God. So this is a play-by-play from in-court reporter Inner City Press as they relayed the whole hearing that the court was just talking about on November 19th. Okay, now, U.S. versus Combs hearing in the MDC jail raid. Inner City Press is covering the cases every twist and turn. Perfect. Will live tweet the thread below. Sean Combs comes in from the holding cell at MDC jail in MDC jail tan, walking fine, hugs his lawyer, sit down, waiting for the judge, still waiting for the judge. Combs is chatting with his lawyer, Anthony Rico, seated to his left in a bow tie, all rise. Sean Combs's lawyers, Attorney A. We expect Alexandra Shapiro to arrive in just a moment from the Second Circuit. I have Sean Love Combs to my left. We're going with Love now. Judge, fine. What are you seeking? Attorney, we want to know how his notes with lawyer attorney-client information came into their possession. Combs' lawyer. He has an expectation of privacy in his legal notes. At least they tailored it. Judge, this occurred during a BOP sweep of the jail, but you're saying it was a pretext. Combs' attorney, yes, 19 pages of notes were given from the taint team to them, the government. Combs' lawyer to the court, we know enough to make out a constitutional violation, but we need to know more detail about the failures. We haven't been able to test their explanation. No, Emily, you ruined it. I was trying to scroll. There we go. It went right back to the same place. Whoop, whoop. We haven't been able to test their explanation. We need the surveillance video of the search. Combs' attorney, we need the communications of Investigator 1. We need to know the role of the AUSA's office on what should be photographs. The search was for drugs, guns, cell phones, but these are Combs' legal files. The judge, keep to the logistics. Defense counsel, we're not sure it was Investigator 1 was the one doing the search. Who interviewed Mr. Combs? Was there an interview? Who went into the area with his legal papers? Once we know that, we could have a Fifth Amendment transgression. We may ask for a dismissal of the indictment. That's not going to happen at this point on this information. But that's what the defense is saying, right? The defense is saying we need to know more, and then we're going to ask for it to be dismissed, and we're going to live to fight in the appellate court another day. We may ask for a dismissal of the indictment or for recusal of the prosecution team. The judge. They used portions in responding on bail, and you want me not to consider those. Defense. They need to hand over the notes. Well, that doesn't answer the question. Defense. We don't know what the taint team has. We want to know. I bet you do. And we want the material back while this is pending. We cannot waive his attorney-client privilege. We have to be direct or aggressive. Not sure which is the right word. What are they doing? Direct or aggressive? The judge, government, what happened here? Why were they taking photos of Mr. Combs's notebooks? AUSA, Slavic, none of the prosecutors had contact with them. Judge, but investigator one was monitoring Mr. Combs's communications in and out. Is this a Fourth Amendment violation? The attorney, the government, the BOP investigator works for the BOP. He is focused on safety. And if the defendant is in compliance with BOP rules, he was not. It is true that BOP gave us the info. None of the prosecution team were aware that investigator one was going to be part of the sweep. Judge, when did you become aware that photos had been taken of Combs's notes? USA, after the sweep. That's not what they were asking for. After the sweep. Judge, but before the grand jury subpoena. Judge, so there's nothing else? AUSA, defense says the defense team does not know what the taint team has, but we made a production to them last night of everything, not just the 19 pages that were passed to the case team. So the defense is in possession of everything the government has, not just the filter team. So the defense has what the filter team has and what the case team has. The case team doesn't have everything the filter team has. So, AUSA, the defense counsel says the defense team does not know what the taint team has, but we made a production to them last night of everything, not just the 19 pages that we passed to the case team. The AUSA said these materials were obtained as part of the government's covert ongoing grand jury investigation. The judge, is it standard procedure to photograph notebooks rather than take them so it could be known that they were taken? AUSA, I don't know. Right, because that's what the jail makes that decision. AUSA, we are not required to notify the defense of our ongoing investigation of criminal conduct. We receive these materials in an appropriate channel. Whenever we get new information, if there's reason to believe there's privilege, it goes to the filter team, the judge. If they were verbatim notes of his meetings with lawyers, how would you know without asking the defense? AUSA, our filter team does a serious job. This investigation was covert. We had a lot of information before charges were brought. That is a whole lot of not answering the question. AUSA, I understand there is a dialogue between the defense and the filter team. I'm not part of that. The judge, I don't understand that dividing line between the covert investigation and discovery in this case, given that the defendant has been charged. And that's where the court's like, what's the difference? The government, our grand jury investigation is ongoing into conduct that has not currently been charged. We have multiple ways to get information that are not obvious to the defendant. We're not obliged to inform them. They have no authority for that. So the AUSA, this is where the government stepped in it. Big pile of llama poo. This is where the government stepped into it. If the government was just investigating, don't use it in your bail motion. Once you've used it in your bail motion, you've brought it into this case. So you can't say it's just part of an ongoing covert investigation because you're now using it in this bail motion to say he needs to stay in bail. The judge, I want to be cautious since some of this is sealed, but is any of this privileged? So the judge is being mindful that once it's in the hearing, it becomes public. No, we need more lip gloss for this. The government, the notebook was labeled things to do, not attorney-client. I bet it's labeled attorney-client now. Things to do, not attorney-client. They suggest they were meant to be in the folder marked legal, but self-labeling is not enough. The government continues, these include action items for non-lawyers. That's not privileged. The information about family members' birthdays, that's not privileged. We point to the Lumiere decision by Judge Rakoff, which is same district. We are happy to engage with the defense. Judge, how about agreeing that I should not consider these two excerpts in your opposition to the bail motion? How about you just don't include it? The government, I think that's right for the bail argument scheduled Friday. The judge, what about putting them in a vault? There are inspirational messages. Well, those are probably not privileged unless Diddy's trying to inspire his lawyers with prose. They're going into the vault with the Lawnerd 1.0 merch. And then they can come out with the Lawnerd 2.0 merch. The government shouldn't have put them in the motion. This is the problem. There are inspirational messages. The government, these are related to our ongoing investigation. There's no reason to put the notes in a vault. Then don't put them in your bail motion. If they're part of an ongoing investigation, don't put them in the bail motion. As a matter of procedure, the defendant would have to make a motion. These notes are not attorney-client privilege. Then there's work product, which is broader. It's meant to protect the attorney mental process, but these are not that. It's about an administrative question. Following up with a paralegal is not protected. The judge, what if an individual had counsel paid by another? The payment not privileged. And if it's about paying off a witness, that is what we are investigating. These notes refer to individual 2, a non-lawyer third party. It's on his to-do list. To do, pay off witnesses. Judge, a defense lawyer can investigate potential witnesses. It would be malpractice not to. If these are about the defense team's preparation for witnesses, isn't it a closer call if it falls into work product? The AUSA, the person tasked is a non-lawyer. The government says on October 18th, the defendant told a family member to work with a non-lawyer to find everything about victim 2. And this non-lawyer individual 2 is not identified as part of the defense team. Yeah, if you've got family members digging up dirt on people, that's not work product. The judge, what about turning over the surveillance video? Yeah, Miguelina, we can end the poll since we're here now. The judge, what about turning over the surveillance video? AUSA, we are opposed. There's no authority for that. The judge, I noticed that. Defense counsel, they want to work with you to try to resolve this. The narrator's note is defense counsel seems to laugh. This is what I love about the reporting of these court proceedings from the inner city press is it's really like this happened in court. It is a fly on the wall recitation, and I love it. Defense counsel seems to laugh. Judge, you may not agree, but why not discuss? Defense counsel, we don't want to give them insight. Combs's lawyer to the judge. There it is. All the legal pads say legal. Oh, it's not just mentioned, it's argued. All the legal pads say legal. What the government is saying was searched is just not accurate. Who's not accurate? Judge, wait. You are saying that photos taken were from pads marked legal? Can you show me? Defense counsel walks up and hands the judge a pad. It gets worse. Defense counsel to the judge. When we visit him in jail, we have lists. Everything in these pads are things we discuss. Trial strategy, who we should speak to undermine a witness's credibility. We discuss everything with Mr. Combs. This is a sweeping racketeering case. Defense continues. We are studying this man's life for our bail application, his charity work. There is not a single day, a single event case. We spend time on every nook and cranny of his man's life. I have a case and then cites the case. Very important case. Combs's lawyer continues to the judge. Mr. Combs came out and read us his to-do list. That is privileged. I mean, it's going to be more finely parsed than that. Just reading it to his lawyer doesn't necessarily make it privileged. The 19 pages include things we have said to him. That's probably privileged. The name of potential witnesses, a retired doctor. Now they have that. This is in the heartland of attorney-client. Mr. Combs comes out and reads us his to-do list. That is privileged. Okay, that was repetitive. Judge, I'm looking at the case you cited. AUSA, are you familiar with that? AUSA, I'm not, Your Honor. Defense counsel, Ms. Garrigus has something to say. Garrigus, they say there's a covert grand jury investigation, but there's a current indictment. AUSA, we're talking about 11 pages of notes, not a stack. Uh-oh. 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 We don't even have a stack of notes. We have a stack of legal pads that seem to be marked legal after the fact. But it's not even a stack. How disappointing. The AUSA, we're talking about 11 pages of notes, not a stack. None of these notes are legal. The judge, the notes themselves are not legal, but the page in the legal pad was marked legal. Oh, the judge is relying on it. Oh my God. Oh my God. The notes themselves are not legal, but the page in the legal pad was clearly or was marked legal. The judge is relying on the defense representation that those notepads said legal during this hearing. And then the judge goes back into chambers and looks at all the photos and goes, the fuck they are. Miss L said in the chat, we can't see the hearings. Correct? Correct. There is no audio or video recording in federal courts. This is the best we got. And what is wild is when Inner City Press is in the courtroom live threading this, they don't know how important this is going to be because the court hasn't pointed it out. And no one knows what the photos of those legal pads are except for the court and counsel because they're sealed. So this is what I love about direct reporting because it's not filtered in any way. It's just, this is what's happening in court. Boom, 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 boom. Nobody knows the import of these pads being marked legal in this way. Listening to this hearing, you're like, oh shit, this is bad for the government. If all those legal pads say legal, that's bad. What we don't know is that the sealed photos show that at the time that they were photographed, they did not say legal. So that the word legal was placed there sometime after the photographs were taken, and defense counsel presented it to the court as if it was the fact the day that these were photographed in October. And that fuckery is wild. Oh boy. The notes themselves are not legal, but the page in the legal pad was marked legal, the court said. The government, it's not clear when the defendant wrote that on. So, the judge, we have a bail hearing on Friday, at which I will not consider these materials. In terms of running down the privilege issues, we can take weeks. Any issue with that time frame? Defense, no. Judge, I'll issue a schedule. Defense, if they are intending to seek a superseding indictment with these notes, the judge, AUSA. AUSA, just to be clear, the filter team can keep the notes. The judge, if they are not involved in the grand jury investigation or this case. Defense, they should preserve the video. AUSA, fine. The judge, what about different case? The government released on 10 million bail. Be prepared to address the difference. The AUSA, it's very different. So the Abercrombie case, The judge was like, what about that case? They got out on 10 million bail. Be prepared to talk about it. The AUSA, it's very different. The judge, see you Friday. And then Inner City Press will be there on Friday. Oh boy. You want to know why I think there's fuckery afoot, other than the fact that the court's like, excuse me, counsel, what? I thought we were just going to go over one court order. I didn't think that all shit was going to break loose. All of the shit has broken loose. The shit is out of the unicorn, the llama, the alpaca, the goat. Everything has taken a shit on this. But you want to know what concerns me about the defense attorneys? Here's what concerns me. They describe these legal pads. And we're going to go back through and look at their description of the legal pads. They describe the legal pads in incredible detail. This legal pad has no vertical line on the side. This legal pad has 21 lines. The first two legal pads have 35 lines. They talk about the legal pads having 3 vertical lines down the left side. The other 2 legal pads have 1 line down the left side. The final pad has no vertical line down the left side. They're telling you how many lines the legal pads have. They've spent an incredible amount of time looking at the photos provided by the government to tell you about the difference in the legal pads. And in this entire motion, they not once, not ever say that the legal pads say legal on the top. The defense is going to have a day in court on Friday. Well, I'll be summarizing that day in court on Friday on Quick Bits on Monday, because Friday I can't stream because my husband has some medical appointments that I need to take him to. So, who thought everything would pop the fuck off? For those of you just joining us, the court has said, be prepared to tell us why the fuck you lied to the court. The court notes on the sealed exhibit that there are 2 photographs of intact legal pads taken in the sweep. There is no writing on the binding of either pad. At the hearing on Friday, defense counsel should be prepared to give the court context on the legal label that the court was presented with on November 19th, and to address why this label doesn't appear on the photographs in the court's possession, and why it wasn't addressed in the defendant's submission to the court made a few hours before the November 19th hearing. You need to tell us what the fuck. Let's try to summarize this. And now 2 hours into the stream, we're going to zoom to Idaho and to Idaho. So let's try to do a summary. Holy shit, that popped off. I was not expecting that at all. Like I grabbed these documents as we were getting ready for Law Nerd Shop 2.0. We had our Zoom call with the mods last night. We were talking about all the things. We were gushing over you guys and how great you are. We were talking about plans for trial for next year. We were talking about the shop. We were talking about all the things. I grabbed these and was like, oh, the judge is just going to issue a scheduling order. Girl. What I didn't know yesterday. Damn. Well. The Diddy case has popped off in an unexpected way. At the hearing on November 19th, it seems the defense counsel provided to the court legal pads that photographs were taken of by the government, and they purported to the court that those legal pads said legal on the binding and that the government should have known that everything in those legal pads was attorney-client privileged. Of course, this is all coming up because the defense is asking for Diddy to get bail again. That hearing is scheduled to happen on November 22nd. But in the government's response that I covered in the podcast on Wednesday, the government said, well, Your Honor, actually, we're even more worried about witness intimidation because of what we've learned from the defendant's notes that were photographed during a raid of MDC that was related to looking for contraband. And the defense came in and said, Your Honor, the government has taken attorney-client privilege information and they are using it against the defendant in their bail motion. And they can't do that, and we might need the government recused, and we might need the indictment dismissed, and the government can't do any of this. Then the defense came into court, showed the legal pads, and said, see, they say legal across the top. The government argued, look, the photographs taken of those legal pads contain information that is not privileged. We sent all the photographs to our filter team to filter anything that might be privileged, and we don't know when that writing got there. And then on November 20th, the court issues an order that says, the court notes that the sealed exhibit to the government's brief includes photographs of 2 intact legal pads taken at the time of the sweep. There is no writing on the binding of either pad. At the scheduled hearing on Friday, November 22nd, defense counsel should be prepared to explain themselves. The court says to give the court further context of the legal label that the court was presented with on November 19th. And address why this label doesn't appear on the photographs in the court's possession and why it wasn't addressed in defendant's written submission to the court a few hours before the hearing. Did the defense go into court and misrepresent those notebooks or legal pads? Because the defense seems to have said to the court, the government willfully took attorney-client privileged information and knew it was privileged because those legal pads were marked legal. And they represented that to the court. And the court is saying, but in the photographs at the time of the raid, that writing is not on the legal pads. And you represented to the court that it was. So on Friday, you better come in here with an explanation as to why you never mentioned it before the hearing and why it's not in the photographs. Did you lie to the court? Is Diddy's legal team in trouble with this? Because the federal judge does not sound happy. Zealous advocacy is one thing. The duty of candor to the court and legal ethics are another. You cannot lie to the court. You cannot misrepresent to the court. You cannot leave out information to the court. And the defense didn't come into court and say, well, these legal pads seem to say legal on it. They said the prosecution should have known because these are clearly marked legal. And the court said, it's not marked that way in the photographs. Oh, defense, you're going to need to explain to the court if you lied on the record. Is the defense going to get sanctioned? They could. Was that a willful misrepresentation to the court? Because you know what? It doesn't seem that they said, and maybe we'll see the transcripts down the road because this is going to get litigated a lot. It seems that they said from reporting, not my client tells me these were marked. They seem to represent it as a fact. Ooh, defense, you in danger. We had to go code red for that fuckery. Oh, I'm waiting to see what happens on Friday. Stay tuned. I'll be breaking it down in quick bits on Monday because damn, this case is going to be like this, isn't it? Though I will say the defense writing in that November 19th submission read like a novella. It really, the drama has been turned up to a 10 in this case, and we are still so far from trial. What's going to happen next? Nobody knows. All right, we're going to go back from Code Red. We're going to fly to Idaho, and we're all going to take it down a notch because damn, today has been wild. Let's buckle up for EDB Air. For all of you saying, Emily, EDB Air launch when? Don't worry, we've got plans. Lawnards, we've got so many plans for the Lawnard shop. You guys are going to be, look, our biggest problem is trying not to do everything at once so we can space it out and make it palatable for the Lawnards. We can't do everything at once. Let's go to Idaho. All right. For those of you asking about the Lawnard shop that came in midstream, yes, Lawnard Shop 2.0 launched this morning. Yes, there are, I think I saw Octo in the chat say there are a few gift with purchases left, which means Lawnards, you guys have been enjoying the Lawnard shop, and I can't wait for you to get them in your hand. I can't wait for you to feel the new gear. I can't wait for you to feel how soft and cozy everything is. I am so excited. I am so excited. But the Idaho judge is not dealing with this kind of fuckery. So cheers to whatever you chose to drink on EDB Air. We're going with water this morning. But you know, I could have put all my fun hydration gear in my Lawnard zip. It's so good. It's so good. I see you guys telling me in the chat some stuff is sold out. We will keep you up to date. Look, if you guys don't have the app, get the app now. If stuff is sold out, you can go ahead and sign up to find out when it is back in stock. Because the limited edition is the pin. If we need to restock other things, we will keep you in the loop about it. The size I'm wearing right now is XL. So Warren's like, haha, is our gift with purchase gone then? Is it gone then? So, Steph Dog, do not worry. We will have launches to come in the future, and I am sure down the road, because I'm always inspired by the amazing Christine at Simply Nailogical, who runs Hello Taco. There are times that she does polls within her member community to bring back out of the vault something that was beloved. So we will absolutely work on bringing things back later. Warren said no. Everyone in the chat is good. If you're watching on the replay, maybe not though. Okay, perfect. All right, y'all, let us go to Idaho. We watched the hearing together. If you did not watch the Idaho hearing, that is what we were referring to. I will try to summarize the best I can. Let me make sure that I've got everything pulled up as we go through this. So we watched the Idaho hearing together. There was an extensive amount of motions related to the penalty in that case. The government has filed notice that they may seek the death penalty in that case, or are seeking the death penalty in that case. It changes it to a capital case. So when I say something is a capital case, it's because that's on the table. It will be decided, if he is convicted, it will be decided by a jury down the road. But all those motions came before the court to try to take some of those motions off the table, or to take that penalty off the table. I don't even remember off the top of my head how many motions it was, 7, 8. It was so many motions. So all of those motions were heard, but they were different avenues to try to take the death penalty off the table. You might have seen headlines yesterday that the court has ruled on those motions. So we're going to go through those motions together. But the court also ruled on some other motions. So we're going to go through that first, just because they're quicker. And the defense filed, oh my goodness, let me pull it up. The defense filed a ton of new motions regarding the search warrant and trying to suppress or exclude evidence. So let me make sure. I'll show you the docket. The docket in the Kohberger case, thanks to Idaho, is public. So we will link it down below. I don't always. Let me give it to Miguelina as I say things and don't provide it, but we will link it in the description, and we can drop it in the chat if you ever are curious about this case. Idaho has made their high profile cases free and available to the public. Yay. Lots of it's sealed, but they have made it available. So as I go through the docket here, I'm just going to show you apologies for the scroll. But since the hearing, we have a motion for leave filed on the 13th. We have an exhibit list that was filed. We have a supplemental request for discovery, a motion to compel discovery. Then we have a motion for a Frank's hearing. We'll talk about that. And then we have a ton of motions to suppress. Sometimes these all become a super motion, like it's a motion to suppress and they make the general arguments and then make specific arguments to each thing. Sometimes they are separate. So they've made separate motions. And the separate motions are the motion to suppress the genetic info and motion to suppress information from Amazon, the apartment, Apple, the arrest warrant, AT&T, the first warrant, which means there's probably a second, cell phone data, Google, pen trace data or pen trap trace data, person in Idaho, person in Pennsylvania. So those are probably searches of the person. We can go through those if we want to. The white Hyundai, statements made in Pennsylvania or connected to Pennsylvania. And then there's a motion for leave. So we're going to go through the motion for leave first, and then we'll go from there. And then we'll go to the court's order, and then we'll go to the motions to suppress. For those of you like motion to suppress everything, witness is like, so motion to suppress everything? Yes, all. But again, we talked about this in other content. We talked about this when we were covering what's going on in the Murdaugh case. Make every argument to preserve it for later. Preserve all of it. So yeah, all of the evidence, they are going to make motions to suppress. But now we have a little bit of a better idea, at least, of what is there. So that's helpful. Let's go to the defendant's motion for leave, and then we'll go back and forth from here. Oh, you know what? Hold on. I think I figured out what I don't like the way it's showing up. I think it is, let's see, if I share the entire window, things keep changing on the software end. No, that's not it. Maybe if I share the tab, it's bugging the shit out of me. The way it's showing up letterboxed is bugging the ever-loving life out of me, and it didn't used to do that. This is a recent change, and I hate it. Let's see if this works. Nope, it didn't. Boo. All right, well, let us continue on. We're going to have to just, Emily, deal with the fact that you hate how it looks. It just changes everything. I like it when it's full screen. It used to be full screen, and now it is not. Don't worry, members. Members are like, uh-oh, tech test stream when? Soon. Soon. Oh, my YouTube chat just crashed. Soon. If you guys are having YouTube chat issues, it's not just me. AdCommet, we're doing this. This is on the list. This year, Team Baker has met a lot of their goals. We've done a lot of things. New merch was a huge part of it. Rebuilding the shop on Shopify was a huge part of it. Building out the app to the functionality we wanted was a lot of it. And so we are a small team. We are a team, but we are a small team. So bandwidth was huge, but building out is top of the list. Building out is top of the list. State of Idaho, defendant's motion for leave. So yeah, Team Baker operates largely on fuck it, we'll do it ourselves. But building software is not as much fun as designing sweatshirts. So that came first. Emily, did we follow the dopamine? Yes. Cozy hoodies are way more fun. Miguelina, it's full screen, so I can't, it's full screen. It used to go top to top, and then it didn't. But we can sort it out later. I'm not going to sort it out while we're streaming. Miriam, there are some reasons. Part of it is the interactivity of chat. I don't want chat scrolling on the screen. I want to bring up chat on the bottom. And that I like. So, all right, let's keep going. Comes now Bryan Kohberger, by and through his attorneys of record, and hereby moves the court for leave from the court's order. You know what? Sorry, chat. the ADHD was like, maybe if I try this one thing, I'm wondering if it's my display ratio. So give me one moment to see if it could possibly be, excuse me, Emily, are we going to make things worse? Potentially. All right, I'm going to do this another time, but I'll work on the screen display ratio and see if it'll fix it. Because right now it's not. It used to work edge to edge, and now it doesn't. I have a 16-year-old. I can't even say the word edge in my house. All right, streaming is dynamic. My annoyance is permanent at this point. Comes now, Bryan Kohberger, buying through his attorneys of record, moves the court for an order governing further criminal proceedings and notice of trial, specifically the defendant's motion deadlines of November 14th. Wait, today's November 21st. When was this filed? Oh, this was filed the 13th. Defense counsel and investigators have not had finished a full review of the vast amount of discovery in this case and will continue to do so. Counsel requests this motion be set for hearing in order to present oral argument, evidence, and testimony in support thereof. Request time is 1 hour. This was a Hail Mary motion. What are they asking for? Motion for leave of what? I think they're asking for an extension of their deadline. It seems like they're asking for a deadline extension. All right, well, let's see the court's order on that. And here, let's just remove this. We're going to share this a different way. The fact that things work and then don't work without any explanation as to why makes me insane. Because then the ADHD urge is to go down a rabbit hole to fix it and not finish the thing I'm doing. I'm struggling so much right now, chat. You know what I mean. You know what I mean. We're gonna get to the court's motion in a minute. Your Honor, we'll be right back. Don't worry. I'm gonna do a verbal ADHD rabbit hole so I don't do a physical one. The ADHD urge to try to fix this now is so strong. This happens when I'm unloading the dishwasher and go to put a dish away. And I'm like, wait, those things shouldn't be here. So those need to move. And then I go to move them. And then there's something in their place. And then that thing needs to move. And then that thing needs to go somewhere, but I don't necessarily know where it needs to go. So then I need to create a home for it. And then I end up with everything on the floor and I am out of energy. And my husband's like, what happened? And I'm like, okay, so I went to unload the dishwasher. And I put these things away in their place. But then there was something in their place. So that thing had to move. And then its place was full. So then that needed to be reorganized. So now there's 900 things coming tomorrow from Amazon and it's all going to be fine. My husband, Emily, what's happening in the closet? I needed to put away a purse that I couldn't reach easily. He's like, but why is everything on the floor? Well, I couldn't just put it away. Everything needs to be redone so that it's in the perfect spot. He's like, but everything's on the floor. And I'm like, right. But I can't just put it away without redoing all of the shelves. I wish I could. I wish I could redo it without undoing all of the shelves. And depending on how much self-restraint or bandwidth I have, it's not really self-restraint, it's bandwidth. It takes bandwidth to just put it away and say it's good enough. It takes so much less bandwidth to lean into the urge to pull everything out, but then you run out of steam. Shit. Red Rocker says, LOL, me too, Emily. I'm getting clear containers to put the closet back together. I did that. I ordered a bunch of stuff to reorganize the bathroom in my drawers. Emily, did you measure the drawers? No. Have the clear containers gone back to Amazon yet? Also no. Emily, is it because you're determined that they're going to fit in some drawer somewhere in your house someday? Yes. Yep. And then I got sick. I was like, this could go faster if I reorganized it. And I love it when I start and I love it when it's done. It's the middle bit that I fucking hate because it's the middle bit where I run out of energy. So now I've started trying to go shelf by shelf that is working better for me, but the day-long side quest. So I've started going shelf by shelf. I'm like, okay, if I can just, to try to keep the doom piles minimal. But anyway, Emily, you're not traveling in the winter, right? This is my time. I travel a lot in the fall, and then nothing gets put away properly because it's like constant travel. And so this is the time to be like, okay, everything can get put back away. So thank you, chat, for derailing with me as I want to fix this desperately and cannot. I know all of you feel seen. The whole chat is like, It's hard. Meta in the chat said that Busy Toddler on Instagram calls it MPRS, mid-project regret syndrome. That's the perfect name for it. I love starting the project. I love the project being done. The middle bit is so fucking painful because the dopamine runs out. But then somewhere in the middle, I either need to find something better to watch or make a new playlist. Making a new playlist sometimes helps mid-project for me, or finding a video. This is why I love long-form content on YouTube and live streaming. When you see me pop into people's live stream chat and I say I'm packing, it's some variation of everything I just verbalized. It's like, Emily, hop on stream. It's like, no. I put this on because I need 4 hours of somebody talking me through what I'm trying to get done. And I can't listen to myself. One nippy hippie said, I usually eat and then feel better. That's a snack also helps. For all the chat, oh my God, perfect MPRS. I'm using this forever. Yes. All right, let's see what the court said. This is from November 15th at 11:20:42. Order denying motion for leave. The court's like, yeah, no. Before the court is defendant's naked motion for leave. Before the court is defendant's naked motion for leave in which he seeks relief from discovery motions deadline of November 14th. As set forth in the governing scheduling order, footnote 1. Defendant asserts his counsel and investigators are still reviewing, quote, the vast amount of discovery in the case and therefore needs additional time to file motions related to discovery. Motions to enlarge a deadline, no embiggening. Motions to enlarge a deadline filed on the eve of the deadline are not well taken. Oh boy. The state's discovery deadline was September 6th. Defendant could have ascertained far sooner whether the discovery motions deadline would pose a difficulty and brought it to the court's attention. Further, and importantly, defendant has not demonstrated with his filing good cause to enlarge the deadline. Why does the court choose enlarge instead of extend? Anyone? He has not set forth what efforts have been made to review the discovery, what portion of the discovery has not yet been reviewed, why it has not been reviewed, or how long it will take to complete such a review. Consequently, his motion is denied. Footnote 2. This order does not foreclose discovery motions pertaining to new or supplemental discovery responses or in the event new information comes to light requiring additional discovery motions. The judge is like, waiting till the eve of disaster is not going to work, which is probably why we see all of these motions on the deadline. All of these are the deadline. Frank's hearing motion to suppress, all of those motions to suppress. And then on the 15th is an order denying the motion for leave. Then we also have the amended petition to appoint special counsel. There is not supposed to be lawn things happening, and if you hear them, it's my house, not yours. Order denying motion for leave, amended petition for appointment of special assistant attorney general, and that is from the states. The state attorney general is coming in to help, but we've already seen that in the case. Stipulated motion to seal all exhibitees, stipulated motion to seal defendant's memo, and memorandum and decision order on death penalty motions. That's what we're going to go to next, and then we will go back. This was filed yesterday. So let us get to the order on the death penalty motions and go through what the court has decided here, shall we? I think we shall. Let's embiggen that. Memorandum decision and order on death penalty motions. Introduction. This is the court's order on all of those motions we heard in court. There was a fleet of them. Defendant is charged with 1 count of burglary, 4 counts of murder in the first degree in connection with the deaths of 4 University of Idaho students. The state has filed a notice of intent to seek the death penalty. Before the court are 12 motions. There we go. The court summarized it. Great. Perfect. Before the court are 12 motions filed by the defendant challenging various aspects of the capital punishment scheme, footnote 2. I'm not reading all those. They are all here. It is noticing all of the motions. We went through the hearing. Go watch the hearing. A hearing on the motions was held November 7th, following which the court took matters under advisement. The court concludes relief in defendant's favor is not warranted on any of the motions. So the court's like, denied. Denied. Relief is not warranted. So let's go through the standards and go through the lawful law and see why the court has decided that. We needed a refresh of the lip gloss because we've been talking a lot today, and we need a new cup of water because we finished this one. And after being sick for like 2 weeks, the throat is still not okay. Also, all of the humidity has been sucked from the air in such an aggressive way. Such an aggressive way. Even my humidifier is trying to keep up. Standards, the constitutionality of Idaho's capital punishment scheme is a question of law. The court decides questions of law. When a party challenges a statute on constitutional grounds, it bears the burden of establishing that the statute is unconstitutional and must overcome a strong presumption of validity. So the presumption is that the statute is valid. Further, when considering these challenges, courts are obligated to seek an interpretation of the statute that upholds its constitutionality. So the court's telling you what perspective it's coming at this from. It is the court's obligation to seek an interpretation that upholds constitutionality. So if it could go this way, could go that way, then you have to seek to uphold it. Doctor Who said, so it's no longer moist. Correct. Correct. Yes. It's very disappointing. The interpretation of a treaty is a question of law, as are matters of statutory interpretation. Remember, because the defense argued international treaties as well. Whether there is an infringement of the defendant's right to a speedy trial presents a mixed question of law and fact. A reviewing court will defer to the trial court's findings of fact if supported by substantial and competent evidence, and will exercise free review of the trial court's conclusions of law. So it is a mixed bag of standards. A motion to trifurcate capital proceedings is a matter of discretion. The court gets to do what it wants. Whether to order separate trials for any claims or issues is discretionary. Consequently, a trial court must 1, correctly perceive the issue as one of discretion, 2, act within the outer boundaries of its discretion, 3, act consistently with the legal standards applicable to the specific choices available, and 4, reach its decision by the exercise of reason. I like the way this court lays out the standards. There are 12 motions here, and the court has done a very good job of saying, okay, the standards are this for this, this for this, and this for this. Because there are 12 different motions, there are different ways the court has to review it. Are we going to go through all of it? No. The fact that the court has summarized it so well, perfect. Analysis. Oh, I like the way this court writes. I like this judge. I like this judge. I do. I do. Analysis. Why is there a footnote 3 on analysis? I can't do footnote voice. I'm not healed yet. I am not all the way well. All right, we'll try. In his motions, defendant raises challenges under the U.S. Constitution and corollary provisions in the Idaho Constitution. However, He did not provide any argument or authority as to why this court should interpret the protection afforded under Idaho's Constitution as more expansive than that provided by the U.S. Constitution. See case law, explaining that the court may declare the Idaho Constitution to provide greater protection than the federal Constitution in some instances. I mean, that's kind of the point of what the states do. Thus, unless otherwise noted, the court will confine its analysis to the U.S. constitutional law. State constitutions may expand. Like if you look at the federal constitution is like the floor, and state constitution can expand above that. So you can add in more protections, but you can't have less. So the state statutes and constitutions can't have less protection than the federal statute or the federal constitution, but it can have more. So you've seen that recently. California has been adding things into its constitution by the electorate. You can add more. States can add it in, can't take it away. So hopefully that helps, especially for our international crew that is like, wait, what? Each state has its own constitution. Then there's the federal constitution. The federal constitution is imputed to the state's constitution as the bare minimum, and then it goes up. So states can go up. California just codified gay marriage into their state constitution. It's not in the federal constitution, but you can add to it as a plus plus. And I think we'll see more states taking on constitutional amendments at the state level because amending the federal constitution is difficult and fraught. But at the state level, much easier to do. So states can add more. Hopefully that helps. An international crew, you are welcome. For the U.S. crew who's like, Emily, why are we explaining this? We have a large international audience. It's like, what is all these different, we have so many different avenues of law between local courts and state courts and federal courts. It's very confusing. And I get it because we have federal prosecutions. We have the state level prosecutions, and then we have local level It's a whole mess. Which is why lawyers are needed, because it's so much. Motion to strike states notice on grounds of arbitrariness. Why won't this highlight? Sometimes yes, sometimes no. All right, annoying, but it is what it is. Defendant moves to strike the state's notice on grounds that Idaho's capital sentencing scheme fails to narrow the class of first-degree murderers who are death-eligible defendants, thus permitting an arbitrary and capricious selection of defendants for death, which is disallowed. He further argues Idaho's scheme is unconstitutional due to geographic disparities as to who is selected for the death penalty. These infirmities, according to the defendant, violate his Eighth Amendment protection against cruel and unusual punishment, his 14th Amendment rights, due process, and equal protection. Sorry, that is my law, not yours. The Idaho Constitution's corollary provisions, as well as the right to uniformity of justice provided by Article 5, Sections 2 and 26 of the Idaho Constitution. In support of his argument, defendant relies in large part on a study conducted and published in a law review article by Professor Eliza Cover of the University of Idaho College of Law. In response, the state contends that both arguments are foreclosed by binding precedent, which means previous case law. It further argues that Professor Cover's article should be afforded little, if any, weight given foundational issues and lack of relevance. Constitutional requirements of a capital punishment scheme. In imposing capital punishment, and again, not all states do, in imposing capital punishment, Idaho has constitutional responsibility under the 8th and 14th Amendments to the U.S. Constitution. I'm going to grab a comment because I saw a comment in the chat I want to get to. Oh, but then I lost my place. I love chat. Today I'm just incredibly scattered because the brain has been all over the place. Sorry about hearing the lawnmower. I know you guys. We have repeatedly asserted that the lawn mowing should happen on non-stream days. And there are days when that is adhered to better than others. Also, when the weather is dynamic, sometimes the lawn stuff happens day by day, but we're getting to the end of the lawn stuff season here. For all of you that are already snowed, apologies. Imposing capital punishment, Idaho has a constitutional responsibility under the 8th and 14th Amendments of the U.S. Constitution, tailored and applied to its laws in a manner that avoids the arbitrary and capricious infliction of the death penalty. So that is the standard under the case law, arbitrary and capricious. To accomplish this, Idaho's capital sentencing scheme must provide a meaningful basis for distinguishing the few cases in which it is imposed and the many cases for which it is not. All capital cases are first-degree murder cases. Not all first-degree murder cases are capital cases. The way you see states do this is generally by having special circumstances. In Idaho, they call them aggravators. I find that confusing because it's different than aggravation and mitigation at sentencing, but they are called different things depending on the state, but they are different factual things. So in the Menendez case, which we have talked about some because they are up for resentencing, the special circs in that case, which is a terrible example because it wasn't a DP case, but there are special circumstances in that case that made it eligible for life without parole vis-a-vis the death penalty versus a 25 to life where you eventually would have parole. And in that case, financial motive was one of those special circumstances. Multiple murder is also a general special circumstance that you'll see, more than one victim. There are other special circumstances and they vary by jurisdiction. The defense argued here that there are so many special circumstances in Idaho that everything could be a special circumstance. And if everything can be, then prosecutors can pick and choose, and then it becomes arbitrary versus a very well laid out, if this special circumstance, then it can be sought. If not, it is supposed to be reserved for the worst of the worst of the worst of the worst. And it is supposed to be a narrow level of first degree murders that could even be sought in that way. And every state has its own scheme for doing that with their special circumstances or their aggravators. Constitutional review, the court says, of a state's capital punishment scheme addresses two separate aspects of the decision-making process: the eligibility decision and selection, and the selection decisions. States must comply with the requirements for both for their scheme to be constitutional. And by scheme, they mean their the way their law is written. Eligibility. The eligibility decision imposes a narrowing requirement on the state capital scheme. To pass constitutional muster, and this is coming from case law, a capital sentencing scheme must genuinely narrow the class of persons eligible for the death penalty and must reasonably justify the imposition of a more severe sentence on the defendant compared with others found guilty of murder. So we're now looking back at the case law that interprets all of the stuff into how the laws are written. State legislatures can satisfy by narrowing the narrowing function in one of two ways: by narrowing the definition of a capital offense, or by, quote, more broadly defining capital offenses and providing for narrowing by jury findings of aggravating circumstances at the penalty phase, which is coming from a Supreme Court case, which is so weird finding it at the penalty phase. I really like, I don't know. I guess I'm just more used to it. Like, do I like it or just do I know it better? I like the California scheme where the special circumstances are found at guilt. And then when you get to the penalty phase, the aggravation and mitigation are a bit separate, but I get it. So it goes on to say you can narrow down the class of like first degree murders into the class that's capital eligible. My brain just wanted to combine those two, in two ways. For states that have attempted to satisfy the narrowing requirement through the enactment of statutory aggravators, the U.S. Supreme Court requires that the trier of fact must convict the defendant of murder and find one aggravating circumstance or its equivalent at either the guilt or penalty phase. It makes sense to me to do it at the guilt phase, but okay. Every legislature gets to do it differently, and I don't want to be a legislature, so I get to just deal. The aggravating circumstances must meet two requirements. First, the circumstance may not apply to every defendant convicted of murder. So like a murder happened is not a narrowing circumstance, because if a murder didn't happen, you're not on trial for murder. Also, it can't just be a first-degree murder happened. It has to take a class of first-degree murders and narrow it further. It must apply only to a subclass of defendants convicted of murder. Second, the aggravating circumstance must not be unconstitutionally vague. That said, if a particular statutory aggravator is vague, state courts are permitted to further define the aggravator through limiting construction. That means the courts are allowed to look at the statute and say, okay, looking at the statute, it might be vague, the courts can narrow it, versus striking it and making the legislature go back and do it again. So the courts can narrow it. Courts are permitted to further define the aggravator through a limiting construction so as to allow the state to meet its constitutional obligation to provide some guidance to the sentencer and avoid the arbitrary and capricious infliction of death. Footnote 5 says, consequently, an Eighth Amendment vagueness challenge to a specific aggregating factor must consider both the statutory aggravator as well as any limited construction placed upon the aggravator to determine whether it adequately channels the discretion of the sentencing body in order to prevent the imposition of an arbitrary and capricious sentence. So when we're talking about judicial gloss, it came up in this hearing a lot. We're talking about whether the judicial construction limits the statute. So they are fighting, at this point, one of the things the defense is fighting is that the statute needs to be thrown out. If the statute is thrown out and somebody's sentenced under the statute, then it changes their sentence. So some of these are being preserved for appeal for if the law changes down the road. And this area of law is changing. So these are arguments that need to be made. So, selection standards. The selection decision aspect of capital sentencing determines whether a death-eligible defendant should actually receive the death penalty. This phase requires individualized sentencing and must be expansive enough to accommodate relevant mitigating evidence so as to assure an assessment of the defendant's culpability. What is important? I'm just adding words. What is important at the selection stage is an individualized determination on the basis of the character of the individual and the circumstances of the crime. That requirement is met when the jury can consider relevant mitigating evidence and of the character and record of the defendant and the circumstances of the crime. That happens at sentencing. So that will happen down the road. I like it when the aggravators are factually specific. Murder for financial gain, lying in wait, depending on the jurisdiction, murder of a witness. So the factual basis, I think, is, for me, my preference in narrowing it down was the crime carried out in this way. I think the nature of the defendant and the aspects of the defendant are appropriate to be argued to the jury at sentencing and let them decide. The facts are this, and then you take a look deeper at the defendant at sentencing, because in my brain, that's what the judges do at sentencing. That's a sentencing consideration. I don't like it when aspects of who the defendant is become part of what the aggravation is for determining it's a capital case. So I have a very, if we're looking at how these statutes should break down, I definitely have an opinion on how these statutes should break down, and I prefer the factual special circs. The Idaho Supreme Court has found Idaho's I think the other things are sentencing anyway. I've said that. The Idaho Supreme Court has found Idaho's capital scheme to be constitutionally narrow. Idaho has opted to satisfy the constitutionally imposed eligibility requirements through the adoption of statutory aggravators, in addition to statutorily carving out a class of murders, i.e. first degree, to which the death penalty may apply. There's a footnote that cites to the code. Under Idaho law, a first-degree murder is a potential capital crime if such person killed, intended a killing, or acted with reckless indifference to human life, irrespective of whether such person directly committed the acts that caused death. That's the first-degree murder. If an individual falls in this category, so that's the first-degree murder. If they fall into that category, at least one of the 11 statutory enumerated aggravating circumstances, several of which are subject to limiting constructions, must be found beyond a reasonable doubt. So in Idaho, there are 11, I will keep referring to them as special circs because aggravating can have multiple meanings in this context as a term of art. So there are 11 statutorily enumerated circumstances. Defendant contends Idaho's scheme has so many aggravating circumstances so broadly construed that the aggravators accomplish no narrowing and create a greater risk of arbitrary death sentences. I think the multiple murder one is pretty clear and it's pretty consistent across jurisdictions, and it is what it is. Were there multiple murders? Were there not multiple murders? It is a fact that a jury will find or not find. And it's a pretty clear one. It's a yes, no. So I don't think that, especially the multiple murder, is not unclear in any jurisdiction that I've seen. It goes on to say the Idaho Supreme Court has determined that Idaho's approach accomplishes the narrowing function in the eligibility phase as required by the Constitution, noting that while a particular aggravator may apply to many murders, the court concluded no one aggravator applies to every first-degree murder, which is all the narrowing is required based on case law. So they said, look, it's not an unconstitutional statute. It doesn't mean that the state can't decide to yeet it later, but it's not an unconstitutional statement. They go on to say, in challenging Idaho's scheme, defendant improperly focuses on the statutory aggregating factors in the aggregate. This is why I like calling them special circs, but I am biased. Defendant improperly focuses on the statutory aggregating factors in the aggregate rather than individually. This approach was rejected by the Idaho Supreme Court, and they cite the law for that. We're going to keep going. Because the defense argues about the case law, the court is going to say the case law is fine. Defendant's attempt to distinguish the Hairston case or the Hairston case is misplaced. The court squarely held that there was no basis to consider whether the aggravators collectively performed the narrowing. Rather, the relevant question is whether the applicable aggravator individually performed the narrowing. Is one enough? So not all first-degree murders have multiple murders. That narrows down the class. Not all first-degree murders have a lying in wait circumstance. So does it matter? Only one. The court goes on to say, additionally, while the Eighth Amendment's narrowing analysis is typically confined to the eligibility phase, the narrowing effect of selection phase and mandatory appellate review that focuses on who ultimately receives the death penalty cannot be ignored. Noting the narrowing challenge to Arizona's capital scheme cannot focus solely on statutory aggravating circumstance because the selection phase and mandatory appellate review provide further narrowing. For this death penalty scheme to be constitutional, both the eligibility phase and the selection phase must contain safeguards to ensure that the process is neutral and principled as to guard against bias or caprice. Yes, in the sentencing decision. It's weird to see it separate from capricious. But yes, Idaho's selection phase requires that the jury weigh all the mitigating circumstances against each aggravating circumstance. This is why I like the California scheme better. I don't know who else does it differently, but in Idaho, what we learned from this hearing is the way this goes in trial is that they present the evidence at the guilt phase. Did the person on trial do the things they're accused of doing? And then you go to, if the jury comes back with a conviction, then there is a separate trial on aggravation and mitigation. Because some of the aggravating factors in Idaho are not just factually specific, and we went through this at the hearing, but because some of them are not just factually specific, the courts have found in Idaho, the defense needs to be able to present the mitigation that you don't necessarily present at the guilt phase, at the sentencing phase. And the aggregating factors are found at the sentencing phase. And then you hear all of the aggravation mitigation also. So those all work together. Idaho's selection phase requires that the jury weigh all the mitigating circumstances against each aggravating circumstance to determine whether the imposition of the death penalty would be just or unjust. The jury must unanimously agree that the death penalty is warranted. If it's imposed, the sentence is reviewed by the Supreme Court to determine whether the sentence was imposed under the influence of passion, prejudice, or another arbitrary factor, and whether the evidence supports the judge or jury's finding of the statutory aggravating circumstance. Thus, importantly, eligible defendants are further narrowed through these phases. So they're saying that the defense has not demonstrated the scheme is arbitrary because it's being applied in different geographical locations differently. So we're going to skip that section, or we are going to be here literally all day because it is a 55-page ruling. So, in sum, the court finds that both arguments advanced by defendant in aid of his arbitrariness motion are foreclosed. Are foreclosed by the binding precedent, and his efforts to distinguish such precedent failed. The motion is denied. All right, motion to strike the individual aggravators. The state has identified 4 statutory aggravators in its notice that it intends to rely upon in requesting the imposition of the death in this case. At the time the murder was committed, the defendant also committed another murder. So that's your multiple murder aggravator or special circ. The murder was especially heinous, atrocious, or cruel, manifesting exceptional depravity. So that goes to the way the murder was carried out. By the murder, the circumstances surrounding its commission, the defendant exhibit utter disregard for human life. Again, that goes more to the defendant. So I think the two and 3 are really close together. But the defendant, by his conduct, whether such conduct was before, during, or after the commission of the murder at hand, had exhibited a propensity to commit murder. I do not like this circumstance at all, which will probably constitute a continuing threat to society. I do not like that circ at all. It is not fact-based. It is very defendant-based. It is very, I find, unclear. I don't like it. But I don't like it. I'm not in Idaho, but I don't like it. And I understand why the defense is arguing against it. I don't like that aggravator. Lying in wait, murders committed for financial or pecuniary gain, multiple murders, murders in the commission, depending on what the other crime is, of other crimes. This one I don't like. So I understand why Idaho's scheme is set up the way that it is, given that this is one of those considerations, because on this 4th factor, the jury gets to hear all kinds of evidence about the defendant and their propensity that you don't get to at a guilt phase, because that's not a circumstance of the murder. That's a circumstance of the defendant. So the court goes on to say, through 4 separate motions, defendant seeks to strike each of the foregoing aggravators for various reasons. The court finds none of the defendant's arguments to be prevailing. So the court then goes through all of the different aggravators, and with all of the different aggravators builds their argument, but the court is not going to remove any of the aggravators. We're not going to go through each ruling again. The website is linked down below. It is a 55-page ruling, and I want to go through some of the other stuff today too. But I appreciate the way that the judge broke this down. I like this judge's writing. I find it to be legally clear. It is thick into the weeds on the law, but that's judge's job. But I like the way he breaks it down. I just don't love that one aggravator. So, but the chat is just freezing like nothing today. Like YouTube is just like, what do you mean live chat? It's more like pause chat. So apologies on that. If I'm not seeing comments in real time, the chat has been a little squirrely today. So they're going through all the case law with regard to the different aggravating factors. Because there are 4 of them, I'm going to zoom through each of those parts off screen so it's not motion-y for anybody. Oh my God. The amount of frustration with the lawn right now. Okay, next motion. Motion to strike state's notice on grounds of failure to present aggravators to a neutral fact finder. Will be done shortly. Defendant seeks to strike the death penalty on grounds that Idaho's capital scheme vests far too much discretion in the prosecutor in determining whether to pursue the death penalty. Well, yes, that is true in every state. If the aggravators are there, the prosecution gets to choose to seek them or not, and oftentimes gets to choose not to seek them, right? They don't seek this in every single case, only in some cases, and that is within their prosecutorial discretion. But they say that that makes the scheme arbitrary and unconstitutional. Let's see. Idaho Constitution, nope. The defense argues that the 5th, 8th, and 14th Amendments of the U.S. Constitution and the corresponding articles of the Idaho Constitution require that eligibility and selection decisions first be presented to a grand jury. No. Before the prosecutor can formally pursue the death penalty. While he acknowledges the weight of the case law from both the United States Supreme Court and Idaho Supreme Court is against him, he argues these cases must be overruled. The state responds that defendant's argument is squarely foreclosed by binding precedent, and the court agrees. The case law says no, you don't have to. The thing is, in some cases, which is again why I like factual aggravators, in some cases the factual aggravator gets presented to a grand jury. A multiple murder factual aggregator is by nature presented when multiple murders are charged. So, footnote 27. The United States Supreme Court has long held that the Fifth Amendment requiring that a grand jury pass on any federal case involving the death penalty does not apply to the states. And then in the corresponding Idaho Supreme Court case, they held that statutory aggravators are not elements of a crime, therefore are not constitutionally required to be included in an indictment and by extension determined by a grand jury. The grand jury does not have to find the aggravators. Sometimes they do by nature of the facts, but that law is well settled. The court says no, moving on to the next. We're literally going thank you next on this argument. The court goes through it more fulsomely. Motion for an order requiring the state to provide notice of non-statutory aggravators and prove beyond a reasonable doubt. In this motion, the defendant moves for an order requiring the state to provide notice of any non-statutory aggravating facts or circumstances it intends to prove at the sentencing phase and provide any such non-statutory aggravating facts or circumstance beyond a reasonable doubt to the unanimous satisfaction of the jury before any juror may consider any aggravating fact or circumstances. This was so confusing when they argued it. I was like, wait, what? The state concedes that by statute, it must disclose to defendant all relevant evidence in aggravation and mitigation that it intends to present at the sentencing proceeding, which is like the sentencing trial. The term all relevant evidence includes non-statutory aggravating evidence. However, the state argues that it need not provide all non-statutory aggravating evidence, need not prove it beyond a reasonable doubt. The state is correct. You have to turn over your evidence in discovery. But I don't even know what they mean by non-statutory aggravators. I think they're talking about other things that go to the defendant to balance out the mitigation in not the special circumstances, but in the other information. So if they come in to bring in mitigating elements about the defendant, the state can rebut those with things that aggravate other things about the defendant. Those have to be disclosed, but they don't have to be proven. They don't go on a jury sheet. So Lexi had asked a great question in the chat. Lexi said, what is the difference between indictment and non-indictment charges? So there's two answers to this. And we're going to lip gloss while we answer those two. In this case, an indictment means that it went to the grand jury. So when you have an information, it has gone to a preliminary hearing. Here there's an indictment, it went to a grand jury. So that's part of it. But when they're talking about non-indicted in this particular fact scenario, They are talking about the special circumstances. In Idaho, they call them aggravators, which are those 4 things that we talked about, the way the murder was carried out, that make it not just a first degree case, but a capital case. Those things do not have to be proven to a grand jury, and they don't have to be part of the indictment, because there is a whole separate due process for those to be pled. Well, not really pled, but to be notified. So the state charges the burglary and the murders. They indict that with a grand jury, and then they go forward with the case. Then they have to file a notice that they are seeking to make this a capital case, and that's where they put in those aggravators that they give notice on. In this case, we read those 4 aggravators. So those aggravators are not part of what the grand jury finds. They're not presented to the grand jury. And I think it could actually be, with the way the scheme is written in Idaho, it could be unduly prejudicial maybe to get into some of that at the indictment phase, because there would be no mitigation to balance it, and that wouldn't even be known yet. So a grand jury does not have to consider the special circs or the aggravators. That is filed by notice. A jury considers it if there is a conviction after trial. So let's see. Where are we? So, motion for order requiring the state to provide notice of non-statutory aggravators and prove beyond a reasonable doubt. Those are part of the sentencing phase. Those don't have to be proven beyond a reasonable doubt. The court said they don't have to be proven beyond a reasonable doubt. We are proceeding on to the next. Thank you, next. Motion to trifurcate the proceedings. This was interesting to see how it was held out. Motion to trifurcate proceedings and apply rules of evidence at the eligibility phase. While defendant acknowledges that Idaho's death penalty scheme provides for 2 phases, a guilt phase and a penalty phase, he contends that it must be trifurcated to ensure his constitutional rights are maintained. To this end, he argues that the penalty phase should be divided into 2 parts. 1 addressing whether he is eligible for the death penalty. 1 determining the appropriate punishment. No, that should be 3. To this end, he argues the penalty. Oh, right. There is a guilt phase and a penalty phase. To this end, he argues the penalty phase should be divided into 2 parts. Normally, you have the guilt phase and then the penalty phase. The defense is saying guilt phase, penalty phase 1, penalty phase 2. So whether it should be divided, addressing whether he's eligible for the death penalty, those are the special circs, and 1 determining whether what the appropriate punishment is, whether it is life without parole or death. Sweet and salty, no, you're not the only person hearing the background noise. It's the lawn mower, as I think I have noted it, much to my frustration, because they are not supposed to be here on streaming days. We have gone a long way to make sure that they are not here on streaming days. But I cannot go outside and make that displeasure known, because we are not done with motions yet. So, but I am trying to keep reading and not pick up my phone to text my husband. WTF is happening. While defendant acknowledges that Idaho's death penalty scheme provides for 2 phases, guilt and penalty, he contends it must be trifurcated so that the constitutional rights are maintained. To this end, he argues that the penalty phase should be divided into 2 parts. We went through that. If the state is permitted to present all evidence relevant to both statutory and non-statutory aggravating circumstances at what time, defendant contends the jury may be confused as to what evidence applies and to what aggravator to apply, so they may misapply the evidence. Oh, sweet and salty, it's fine. It's not just you, but also on the replay crew, somebody's going to be like, what in the world is it? So no need to apologize. I'm salty about that, not this, because I find it highly distracting. I am incredibly noise distracted with ADHD. It was real hard during the bar exam in a literal giant convention hall with people typing on laptops. It's hard. The noise. Defendant contends the jury may be confused and misapply the evidence, and that trifurcating would ensure that the jurors consider the appropriate aggravator at the appropriate time. He also contends once trifurcated, the Idaho rules of evidence should apply to the eligibility phase, given that it is akin to a guilt phase. The court, when they were arguing this, said, isn't it malpractice to do that? And it was wild. The state responds that defendants' position is simply one of public policy and ignores the plain language of the rule. It points out that that IC 19-2515 calls for a single sentencing proceeding, which has been the general practice of capital cases in Idaho and contemplated by the death penalty sentencing instructions. The state further points out that defendants' proposition of leaving the presentation of mitigating evidence for the last phase would have unintended consequences of highlighting the aggravating evidence. This issue is a matter of first impression in Idaho, which means the courts have not really balanced all of this yet. This issue is a matter of first impression in Idaho, balancing the benefits and detriments that may be posed by trifurcation and considering trifurcation in an exception to the rule. The court will proceed in accordance with the statute rather than depart on an extra statutory quixotic journey through trifurcation. Oh boy. The court's like, I am disinclined to acquiesce to that request. Sam says my chat keeps freezing. You are not alone. You are not alone. You are not alone. My chat has been crashing today too. The court's like, I'm just going to go ahead and stick with what they wrote in the law rather than depart on an extra statutory quixotic journey through trifurcation. I love, there's times this judge just absolutely it tickles me with the way that he proceeds through things. The birth of the bifurcated death penalty proceedings in Idaho. Uh-oh. In 1972, the United States Supreme Court determined that the death penalty constituted cruel and unusual punishment in violation of the Eighth Amendment if it was administered arbitrarily or discriminately. The decision served to invalidate most every capital punishment scheme adopted by the states for giving too much discretion to the sentencer. In response, state legislatures, including Idaho, revamped their statutes. One of the statutory structures that emerged allowing the sentencer to weigh aggravating and mitigating circumstances in a separate sentencing phase conducted after the guilt phase. In Gregg, the United States Supreme Court considered and approved one such scheme adopted by Georgia. Georgia's scheme specified statutory aggravating circumstances, one of which must be found by the sentencer beyond a reasonable doubt before the defendant was eligible for the death penalty. The sentencer was permitted to consider any other appropriate aggravating or mitigating circumstances prior to recommending a sentence of death. To accomplish this, Georgia adopted a bifurcated system that segregated the guilt phase from the penalty phase. In finding the bifurcated system best addressed the constitutional deficiencies identified by the Supreme Court, the reevaluating Supreme Court quoted approvingly from the drafters of the model penal code to wit: if a unitary proceeding is used, the determination of the punishment must be based on less than all the evidence that has a bearing on the issue, such, for example, as the previous criminal record of the accused, or evidence must be admitted on the grounds, noise. Yep, apologies. I'm waiting for my HOA to complain about that leaf blower, because that's going to happen. That's going to happen. All right. Let's see. If a unitary proceeding is used, the determination of the punishment must be based on less than all the evidence that has a bearing on the issue, such, for example, as a previous criminal record of the accused, or evidence must be admitted on the ground that it is relevant to the sentence, though it would be excluded as irrelevant or prejudicial with respect to guilt or innocence. This is the problem, that there has to be the evidence that comes in at sentencing is sometimes more prejudicial at the guilt phase but you can consider it at the sentencing phase because guilt's already been determined. Trial lawyers understandably have little confidence in a solution that admits the evidence and trusts to an instruction that the jury that it should be considered only in determining penalty and not in assigning guilt. Sometimes you can't unhear things. The obvious solution is to bifurcate the proceeding, abiding strictly by the rules of evidence until and unless there is a conviction. But once guilt has been determined, opening the record to further information that is relevant to sentence. This is the analog of the procedure in the ordinary case when capital punishment is not an issue. The court conducts a separate inquiry before imposing sentencing. So they're liking the sentencing trial to a sentencing hearing. Lots of things come in at a sentencing hearing, including witness, sometimes people are sworn, sometimes they're not, but victim impact testimony, sometimes there's witness testimony, sometimes there's statements by the defendants themselves, their attorneys. So a sentencing proceeding when the judge is sentencing is, hey, let's consider a more broad application of information that doesn't go to whether somebody is guilty beyond a reasonable doubt. And so they analogize it, which I appreciate. While the court was clear that Georgia's scheme was not the only way a statute could pass constitutional muster, it indicated that it was the best. You're the best, Georgia. Georgia's like, can we go back there? You're the best, Georgia. You guys came up with a good idea. It makes logical sense. You guys went, how do we do it now? Oh, we do it this way. Great. Let's do it that way. Let's just separate the two. And once one statute passes constitutional muster, all the other states are going to go, can we get a copy of that? Can we get a copy of that? We're going to get a copy of that. Can we do that? Can we do that? Also, any digs taken at the lovely state of Georgia, which both has an IKEA and a Kura and some delightful shopping, are directly related to the YSL case. All of them are directly related to the YSL case because damn, that case has been a struggle for me. So all court digs at Georgia are specific to that one case because otherwise it's amazing. Kura is a sushi restaurant and they do not have one in Tennessee. They do have one outside of Atlanta. They also have IKEA and Atlanta is closer to me than Memphis. So, sushi and meatballs, whatever you're looking for. Like Georgia, Idaho revamped its death penalty scheme in response to the Furman decision, providing for a separate sentencing phase during which the court would weigh circumstances and aggravation and mitigation. The bifurcated process continues to this day. Great. Pros and cons of trifurcation. We're not going through it. The court's denying it. But if you would like the intellectual exploration, go grab the court's decision. The court has really walked us through not only the law, the case law, the statutory history, the evaluations of the statutory history. I mean, the court's just going there. Trifurcation is not warranted. Defendants' arguments in favor of trifurcation into a guilt phase, eligibility phase, and selection phase largely echo the notes above. Defendant contends that operating under a bifurcated model, in his case, would cause substantial prejudice, confuse the jury, and violate his constitutional rights, including his right to confrontation, his right to due process, his right to a fair trial, and his right to protect against cruel and unusual punishment. He anticipates there will be substantial evidence of non-statutory aggravation, including emotionally charged victim impact evidence and evidence of his own past and character. This is why, in some jurisdictions where all of the aggravating factors or all of the special circs are factually based, they're found during the guilt phase, not during the penalty phase. So here, all of that comes in at one phase. The defendant argues he will be unfairly prejudiced by the free-for-all presentation of statutory and non-statutory aggravating evidence at once, and there is a good chance the jury will be unable to segregate the evidence properly despite careful instruction. Moreover, he contends that because the eligibility decision is, under the Ring case, akin to the guilt phase, it should be subject to the rules of evidence like any other enhancement evidence permitted under Idaho law, like a weapon enhancement or in narcotics cases, there are weight enhancements, like the more drugs, the more sentencing. And those are weighted at the time, but those can aggravate a sentence or enhance a sentence, prior convictions, stuff like that. The court, however, does not believe trifurcation will be as beneficial as defendant hopes. Since it was enacted, the statute 192515 has contemplated a bifurcated process in capital cases. Thus, trifurcation, even if permissible under the statute, is an exception, not the rule. The court does not find the exception is warranted here. Done and done. And then the court goes into why. Look, if they got rid of that one wonky aggravator, they could just do it in the penalty phase. Motion to strike death penalty on grounds of state speedy trial preventing effective assistance. This was an interesting argument. And we're probably getting towards the end of this hearing or this motion. No, order. We're in an order. It's been 3 hours and 15 minutes. But the defense was like, well, Your Honor, we had to waive speedy trial in order to provide effective assistance of counsel, and that places two constitutional rights squarely at odds with each other, and that's not okay. In seeking to strike the death penalty, defendants' multifaceted argument begins with the premise that this court should overrule decades of Idaho appellate precedent, oh, my in-ears are pulling on my sweatshirt, and conclude that the right to a speedy trial is guaranteed by Article 1, Section 13 of the Idaho Constitution, and that should no longer be governed by the Barker factors, but should be subject to a 6-month speedy trial clock. He then asserts that as a capital defendant, he cannot attain effective assistance of counsel within a 6-month period. Thus, at the time he waived his statutory and constitutional speedy trial rights, he was presented with an unconstitutional Hobson's choice between, not a Sophie's choice, anyway, pop culture, between his constitutional right and to a speedy trial and his constitutional right to effective assistance of counsel. Yes, sometimes constitutional rights butt up against each other. Sometimes they are rights of two different people. Sometimes they are rights of the same person. He has multiple rights. You have to choose. Defendant argues this choice rendered his waiver involuntary and deprived him of his constitutional speedy trial rights. Look, the defense is still coming in here making motions saying, Your Honor, we can't meet our deadlines because we haven't had enough time. But they stood in court on this day with their whole chest saying, Your Honor, we want to reinstate our speedy trial right, and we want to advance the trial date. And then in another motion, they're sitting here going, Your Honor, we need more deadlines. We need to push our deadline because we're not ready to make all our discovery motions yet. Speedy trial rights. A criminal defendant enjoys a constitutional right to a speedy trial under both the U.S. and Idaho constitutions. The key difference between the rights is when the speedy trial clock begins. For the past 50 years, the Idaho Supreme Court has analyzed the defendant's rights under both constitutional provisions, state and federal, using a balancing test in Barker. The factors are the length of the delay, the reason for the delay, and whether the defendant asserted the right to speedy trial, and the prejudice to the defendant. In addition, Section 193501 affords criminal defendants a statutory speedy trial right that provides additional protection beyond what's required by the constitutions. The statute mandates in relevant part that unless good cause is shown, an indictment or prosecution must be dismissed if a defendant whose trial has not been postponed upon his application, that's the waiver, his application, is not brought to trial within 6 months from the date the defendant was arraigned before the court in which the indictment is found. So from the time they're indicted, remember, there was a waiver of preliminary hearing early. There was going to be a preliminary hearing. Then he was indicted. At the indictment, the trial clock starts. So there's a prelim clock and then a trial clock. And he's arguing that when the trial clock started, that he was forced to then waive his speedy trial because the defense didn't have enough time. He had already waived his prelim clock for almost a year. So it's not well taken by the court, it seems. This court is bound by Lindsay case law to apply the Barker facts, which avoid a quote-unquote Hobson's choice. Defendant contends that in adapting Barker to analyze speedy trial violations under the Constitution, the Idaho Supreme Court and Lindsay misconstrued the framers' intent to define the speedy trial guarantee by reference to the corollary statutory right provided by 1935-01. This court, however, is bound by the case law. Lindsay. Consequently, defendant's state constitutional speedy trial right is governed by the Barker factors. Moreover, the application of the factors obviates any argument that the defendant was faced with a Hobson's choice between his constitutional right to speedy trial and effective assistance of counsel, thus rendering his waiver rights involuntary. The Supreme Court found that a constitutionally permissible reason to delay trial is to allow defense counsel adequate time to prepare. We have seen this in a variety of jurisdictions. Sometimes the defendant can be sitting in the chair saying, I want to go to trial, Sarah Boone. And then the defense attorney can say to the court, I am not ready for trial. And the court can then put over the trial because the defense attorney has said, I am not ready. And that is good cause. And I am finding good cause. And in finding good cause, we are pushing the trial out. It goes on to say that the defendant's election to waive speedy trial rights resulted in him missing out on the statutory benefit of a 6-month deadline. There is nothing impermissible when the defendant is forced to choose between a statutory right and a constitutional right. Defendant's assertion that his waiver was not voluntary because he was forced to choose between two constitutional rights falls flat. Ooh! The court's like, nah. As it stands, defendant has validly waived all speedy trial rights, which is dispositive of any claim that he has been deprived thereof. The defendant has not presented any valid basis for second-guessing the case law that is binding or the statute that is binding. And so we're going to zoom to the end of the court's analysis on that. Consequently, the court does not find defendant's argument for calling the binding statutory holding in Lindsay into question. Motion to strike state's notice on grounds of international law. No. Defendant next contends Idaho's death penalty scheme violates the International Covenant on Civil and Political Rights, the ICCPR, ratified by the U.S. in 1992. The ICCPR prohibits cruel, inhumane, or degrading treatment or punishment and the arbitrary deprivation of life. He asserts that Idaho's failure to comply with the ICCPR violates his state and federal constitutional rights. The state responds that Idaho's death penalty does not run afoul of the treaty. The court agrees. What is footnote 42? At defendant's request, the court takes judicial notice under IRE, Idaho Rule of Evidence 201C1, of the following documents appended to the defendant's motion. The United Nations General Assembly Resolution 217A 111, 10 December 1948, and the ICCPR and the International Covenant on Economic, Social, and Cultural Rights, and the Covenant Against Torture and Other Cruel and Inhumane and Degrading Treatment or Punishment. So the court took all of that into judicial notice, and the court says, look, Idaho's death penalty does not run afoul of any of the international law. Done and done. All right. Let's see. We should be getting, I'm not going to go through the court's illumination of international law. Motion to strike state's notice on grounds of contemporary standards of decency. Relying on various data points and information from several fronts, defendant contends that the imposition of the death penalty no longer comports with evolving standards of society, and therefore the state's effort to impose the death penalty against him violates his constitutional right to be free from cruel and unusual punishment under both the state and federal constitutions. If Idaho does not like their statute, they can get rid of it. That is their choice. In response, the state points out that only 9 years ago, the Idaho Supreme Court rejected this argument in the Abdullah case, which reaffirmed 4 years ago, which was reaffirmed 4 years ago in the case of Harston versus State with regard to defendants under the age of 21. There are some differences based on the age of the offender, for sure. The state contends defendant has not established any significant change since those cases were decided that would warrant a finding that the death penalty is no longer constitutional, and the court agrees. Look, that goes to the legislature, that goes to the voters, that goes to the state to decide. So that law may change, that law in Idaho may change, but the court says that the case law is valid, the case law stands, this has been reevaluated recently, and it has not changed. Motion to strike state's notice on grounds of means of execution. There was lots of argument about this at the hearing about whether or not the lethal injection was available, whether or not firing squad was available. The court summarizes this as such. Defendant seeks to strike the state's notice on grounds that Idaho's statutory method of execution violates the 8th and 14th Amendments of the U.S. Constitution and the corollaries in Idaho. Currently, there are two methods of execution prescribed by the Idaho statute: lethal injection and firing squad. Defendant, that is accurate. Footnote 50. Wait, no, we're not there yet. Defendant asserts that Idaho currently does not have the ability to kill a person by lethal injection, footnote 50, and the firing squad is not only currently unavailable, it is cruel and unusual. To this end, he provides the affidavit of Barbara Wolf, MD, opining as to the conscious pain and suffering an individual executed by firing squad will suffer, footnote 52. Defendant further argues that it's unconstitutional to allow him to sit on death row without knowing how he will be executed. The state responds that the defendant's motion must be denied as it is not ripe. It is foreclosed by the United States Supreme Court jurisprudence, and it is factually insufficient because he has failed to identify an alternative method of execution. The court agrees. Not ripe means we're not there yet. If he's convicted, if he's sentenced to death, if lethal injection is still not available, then you can make this motion, but not now. And I know many will say, okay, well, I'm sure it's stressful for you if you are convicted and if you are sentenced to death. I'm sure that there is some psychological stress to sitting on death row. However, there is the argument that the victims had no such choice. And they did not get to choose what happened to them. They did not get to choose what happened. Their pain and suffering doesn't even get brought up until sentencing. So some of these arguments are just not ripe and are just not well taken at this point. If he is convicted, if he is sentenced to death, if it survives the initial appeals, then this can come up. But this is not a for now argument. Let's see. We're going to go through the footnotes because there's a lot of footnotes. So there are times where arguments like this in cases are difficult. The defendant is presumed innocent, of course, but this truly is just not ripe. But I'm interested in all the footnotes because there's a bunch of them. Footnote 49 has a website or two websites. Footnote 50. Defendant provides no basis for his assertion that death by lethal injection is not available in Idaho. In February of 2024, Idaho attempted to execute Thomas Creech. We heard about this at the hearing, was unable to do so due to the inability to establish reliable intravenous access, not because the drugs weren't available. Well, not being able to find a vein is a whole different thing. I mean, that's a whole different set of circumstances. In fact, Creech was scheduled for a second attempt of execution by lethal injection on November 13th, but it was suspended due to a stay imposed by Idaho's federal district court. Therefore, at the current time, it appears that lethal injection is available as a means of execution, but that defendant had a physiological difficulty with getting access to intravenous access. That's different. Moreover, even if it were not, any anxiety a defendant may experience from not knowing how he is going to be executed does not implicate the 8th Amendment. The psychological strain, the subsequent nightmares and trauma that the defendant experienced preparing for a failed execution in anticipation of a second attempt is not an 8th Amendment violation. And then the argument is that the facility for a firing squad has not yet been built. Well, that's an odd, well, no, I imagine Idaho doesn't regularly use a firing squad. It goes on to say that the state objected to live testimony by Dr. Wolf on grounds that because this is not ripe, her opinions would not aid the trier of fact in determining a fact of consequence. The court orally granted the objection, finding that the affidavit was sufficient. Yeah, it's not ripe. Defendant's motion is not ripe. To be justiciable. Can we use to be evaluated? To be justiciable. The issue must be ripe. Ripeness is a part of justiciability that asks whether there is a need for the court action at the present time. A litigant must demonstrate an actual controversy exists and that the requested relief will provide actual relief, not mere potential relief. And then they go through whether or not something is ripe. I want to see what the court says at the end. Avoidance of defendant's distress is not a basis to contravene well-settled rules of justiciability. Consequently, the motion fails. This is what I wanted to get to. I wanted to see how the court phrased it. Yes, it's not ripe yet. Avoidance of defendant's distress is not a basis to contravene well-settled rules of justiciability. You might like me to decide now, but now is not the time. It is not ripe. Look, Lawnards. Today's legal word of the day is ripeness. It doesn't just apply to fruit. It applies to arguments with literally anyone in life. It is if this, then that, what about this, what about that? Well, that question is not ripe yet. If the first thing that has not happened, we do not need to go all the way down the rabbit hole and decide everything else. It's just not ready to be decided. So if you would like to kick the can down the road to another day, tell your children, spouses, friends, and family that the issue is just not ripe yet. Lara said, my anxiety, is this thought ripe? This is perfect. This is not ripe yet. We are borrowing troubles from tomorrow that we do not need to borrow. This is not ripe. We will deal with it if, when it happens. So ripeness works. Buffy said, what if any that's overly ripe? If it's overly ripe, then it's moot. The time has passed. We then get into mootness. Nope. We are past. It is done. All right. We're not going to go through firing squad being constitutional. Oh, we're at the end. Based on the foregoing analysis, defendant's death penalty motions are hereby denied. It is so ordered. Judge Hippler, that must have taken some energy, my guy. That was A, great legal writing, B, a really thorough walkthrough of 12 motions, and in only 55 pages. 3.5 hours later of stream, I didn't realize that the Diddy stuff was going to take us so long today. So here's what I propose. I would like to get to some Q&A. That was such an extensive motion, but hopefully instead of just being like motion was denied, we A, all learned something about the law, and B, learned a lot about the thoughtfulness of this judge. I would like to go through the other motions and summarize them for you, probably on the podcast, the search and seizure motions. I think there's probably a lot to be learned from them, but there are the Franks motion, or the motion for a Franks hearing, the motion to suppress the genetic info, Amazon, the apartment, Apple, the arrest warrant, the first warrant, the pen tap trace. I think it might be helpful to go over all of these and see what new information we learn all together. So I think what I'm going to do is say that these are not ripe for today. That's enough work for today. And then do these on the pod, because there's a lot of information here and we're going to learn. I wonder, we're going to learn more about the evidence in this case because we don't know a lot about it. Heather said, what is the Valo stuff on the bottom? This is the Idaho docket of high-profile cases. So all of the high-profile cases in Idaho are on this website. They are not in any alphabetical order. They are by time. So when you go through this, You will see the Creech case we just talked about. There are Supreme Court things going on. You will see other cases that have come up. And then all of the docketing items in all of those different cases are here. So all the way through every docketed item in each case. So the Vallow Daybell cases are on this same website. It's linked down in the description. So that's why. So these are all their high profile cases. So that's why there is Vallow stuff at the bottom. So I'm going to go through that. For those of you asking what's a Frank's hearing, it's a hearing with regard to the sufficiency of the search warrant, but we'll go through that. We'll go through that on the podcast. So there will be a new podcast for you next week. I was not going to stream it all next week. I had completely forgot until Team Baker reminded me, because I have been very focused on A, being sick, and B, Law and Order Chop 2.0. Because I mean, it's Law and Order Chop 2.0. It's Law and Order Chop 2.0. So I've been very focused on those two things. I completely forgot that on Tuesday there is a Karen Reed hearing. So we'll be back on Tuesday for the Karen Reed hearing. If you do not have the Law and Order app, now is the time, because we can notify you regarding the shop. We can notify you regarding Tuesday. So Monday, there will be a new Quick Bits. We will talk about Diddy at all. There's my list for Quick Bits right now is like 10 items already. Quick Bits is not going to be quick. So there will be Quick Bits on Monday. There will be a Karen Reed stream on Tuesday at whatever time court is. We'll just stream court. Wednesday, there will be a new podcast going through all of these motions to suppress. Thursday, there will be food. Friday, there will be a stream with me and Dr. B. Emily, you were supposed to take the week off. Tuesday, there will be a concert. I will get some behind the scenes. So when we've got some additional members only live streams coming up next month. So we'll have some behind the scenes concert footage. So Emily, you're supposed to take the week off. I'll have content for you Monday, Tuesday, Wednesday, and Friday. So we're taking Thursday off. I will be in the chat on Wednesday. That's going to get pre-recorded. If anything else comes in, that's going to get pre-recorded, because I don't want Team Baker working over the holidays. It was one of the things we struggled with making this Law and Order launch. I wanted to make sure that Team Baker had some downtime over the holidays, because it's been so incredibly busy with trials this year. But I also wanted to make sure that stuff would ship before the holidays if you wanted Law and Order stuff before the holidays. So that was the balance of closing Law and Order Chop 1.0, launching Law and Order Chop 2.0, and making sure that if you were if you got your orders in, that they would be there before the holidays. If things have sold out, and it looks like some have, we will keep you in the loop on restock. The pins will not be restocked. Those are limited edition. I would imagine, are probably out of our gift with purchase. If we are not yet, then yay, pleasant surprise. Woohoo! Let's get to some Q&A, and there will be content for you. Well, all week next week. And if you remember, there will be an E and Dr. B Thanksgiving. I will put up a post in the member spaces. One of the things I tend to enjoy doing with Dr. B is explaining internet drama to him. But I think we'll also have to talk about the Jake Paul-Mike Tyson fight, or at least the parts of it Dr. B was awake for and had not fallen asleep for. We're going to explain some Real Housewives drama to Dr. B, and maybe we'll have to pick which internet drama we try to explain to Dr. B, because there's been so much of it. So which tale will we tell Dr. B on Friday? So with all of that, let's get to some Q&A, and then I am going... and then we were going to be done with this stream that ended up much longer than I thought it was going to be, because fucking Diddy, dude. Spicy Vet Mad said, will you make a post in the app? We do, and we will, and we notify in the app for sure. So we will. We have talked to him. I have talked to him none about Lunchly. I've talked to him none about Lunchly. I also, Dr. B knows YouTuber Rosanna Pansino from Nerdy Nummies because my kids love the Nerdy Nummies and they like video games and all of the rest of it. But Dr. B has not seen the updates from Rosanna since her father has passed. We might have to get his reaction to that as well. We might have to be like, so maybe this. We might know to explain all of that. Buffy, can you explain a Diddy freak off to Dr. B? No. There were times I came home from work and Dr. B's like, I can see your face. I don't want to know what cases you're working on. The Diddy freak offs are going to be within that realm of like, I don't want to know. I don't want to know. I argue that Friday isn't work as it's a Kiki with Dr. B. That's true. It is a Dr. B Kiki. Friday is members only. The Dr. B streams are our members only streams. Dr. B might want to know. Dr. B doesn't know. I might need to tell him. So we'll see. We'll see what's going on with that. So Aaron said, if I was married to a lawyer, I don't want to know. There was, especially when I was working in juvenile court, Dr. B's like, don't tell me. I don't want to know. 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 There are things he just did not want to know, and you can't unring that bell. But all DAs have DA friends, and we just, trauma bond with each other. It's like, can I tell you about it? The calls start with, I have the most fucked up thing I have to tell you, and then they go from there. So that is what it is. Thank you to everyone who's gifted memberships. I absolutely appreciate it. And I know the Law Nerds appreciate it as we have lots of members only coming and members only stuff happening. For all of the members that got your Law Nerd shop orders in yesterday, you all get gift with purchases. We release launches to the members first in the member spaces and in the app in the Law Nerd Lounge. So all of you got that first, which is fantastic. Nor said, Emily, that's the wrong definition of a trauma bond, but I get what you mean. It might be the wrong definition of a trauma bond. We all re-traumatize one another with sharing our secondhand trauma from work. So it might be, but I don't know. There's times it feels like, being in the trenches with your coworkers. Emily Outdoor says, hoodie and Paragon in other sizes. What Paragon? I'm going to need help with that, Emily Outdoors. I'm sorry, just at me and let me know. I'm not sure what you mean, but there is a contact us on the website too. So if you have stuff for the shop, there is a contact us on the shop for shop customer service. Otherwise, the mods take notes. Will there be another merch drop before the holidays? No, there won't be. I will talk to the team about whether or not we can restock anything and get it to you before the holidays. But I will let you know. Let's see. I saw somebody mention the pin. I wanted to grab it. Where did it go? Where did I put all my stuff? Oh, it's over here. I saw that the pin would look amazing on my lab coat. Where did it go? It jumped. The pin will look amazing on my lab coat. Yes, it will. It is so nice and shiny. So that is the size of the pin. It's a little larger than a quarter. I love it. It's very tattooy. Paragon is the alternate color. Overnewbin, thank you. My brain is so full. We have exhausted this particular distributor's size range, but we are always looking for new distributors. If anything is out of stock, I will be talking to the team after stream about restock. So yes. But if that is a request, will you let me know what size you are requesting in the, you can shoot us an email or the mods can grab it for me and we will know. So a lot of you are saying, I want the dark navy in smaller sizes. Well, I'll talk to the team about it because a lot of you guys are saying, can we get that colorway in the entire size range? It seems to be what you're saying. Let me talk to the team because I can't give you that answer at this point, but we can, and we will keep you up to date in all of the spaces. Let's see. I'd argue Friday isn't work as it's a Kiki with Dr. B. True, but it was still, I was trying to do days, some days not streamings. So is the Law Nerd hoodie in navy coming in smaller sizes? Okay. So a number of you have asked for the colorway from our extended sizing to be extended. I will take that note back to the team and let them know, because you guys are looking at the hoodie from the Law Nerds Rock hoodie in the darker navy, not the, hold on, This is more of a heathered navy. So you guys are asking for the darker navy. Let me ask when we talk about relaunch. So I will ask about the darker colorway. Yes, I can. So, okay. All of you guys are saying yes, 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 yes. All right. Note made. It's this one. So you guys are looking at this colorway. Note made, because we've got the heathered navy colorway and you guys are looking at that darker navy colorway going, can we get that one? Yes. Okay. Lawnard's 10-4 loud and clear. I will keep you guys posted on the shop. Also, a lot of you signed up for shop notifications. If something is out of stock, you'll get those in-stock notifications as well. For those of you asking about zip-ups, those are coming in future launches. For those of you asking about the light navy, it's heathered navy. So it's got a little bit of that like heathered gray look to it, which I absolutely love. So it's got a little bit of a more heathered look as opposed to the darker navy. So let's see. The one you are wearing, the one I'm wearing, so the other colorway of this one as well. You guys are like, yes, yes, yes. Don't worry, zip-ups are coming. Casey Cat said, Emily, can we get a drama llama added to the Lawnard shop? I mean, the drama llama comes from like way, way back in the day in all of the planner communities. It's not new to me. So let us continue with questions and then I am going to roll because I am frankly getting hungry and I have not been hungry in like 3.5 weeks because I have been just sick. So don't worry. I see all of you asking about future launches. Don't worry. We have a list of what we want for future launches. Do not worry. The court's prudence is ripe. Thank you, Paul. Emily, chat, you rock. Hanging out is the best. I know I love being here with you guys. I'm actually really excited to go 3 days a week because then we can, it would be really nice to be like, oh, we didn't get to this today. We'll just get to it tomorrow. It'll be really, really nice. Maybe a drama llama sticker. Oh, there's definitely going to be a note. But also because I have been sick, the hunger levels have been low. We're going 3 days a week. Laura, we are going 3 days a week in the new year. So that is in the podcast anniversary episode. I talked about it a little bit, but yes, we are going Tuesday, Wednesday, Thursday live streaming in 2025. EJ said, it's my 30th birthday today. The one Emily to, from one Emily to another, big love. Thank you. And EJ, happy birthday, Emily. Cheers. I saw a number of birthdays in the chat. Cheers, cheers, cheers. So don't worry, you guys, we have new launches coming. Not before these holidays though. New launches in 2025. And trust me, from all of your feedback, we will continue to take your feedback to make the next launch even better. And that is our goal for every single launch, especially as we've rolled out our own sourcing and distribution. Slayer says, I can't wait for my Lawnard 2.0 merch. Ordered it immediately. I am so excited. I cannot wait for you to get it. Beating video games made me an ADHD completionist. I like that you're like, okay, ADHD completionist. We'll see it. I need to see it that way. Sometimes I can't. Christine said, I have a drawer of dopamine loss. I know it really is. It's like, where did we run out of energy? Here. I see a lot of you saying that you would like the pens by itself. Look, the things that you guys loved, trust me, Octa was in the chat making all of the notes for the stuff that you guys want going forward. So do not worry. Notes have been made. And our entire team at Bright Ideas is like, oh, we know. Don't worry. Team Baker wants to like bibbity boppity boo all your wishes. So do not fear. It is making sure we can fulfill them, get them to you, and that they are excellent. That is harder than bippity boppitying. Allison said, happy birthday to me, 45 today. I beat endometrial cancer in July. Congratulations. This is a special birthday. It is, Allison. It is. Aging is a gift. Have a whiskey on me, EDB. Stay cool, Law Nerds. Happy birthday, Allison, and congratulations. Take care of yourself. I know there are times that I complain about aging, mostly when I have to move my phone back, but also it is always a gift. I get it. Sparkling Rutabaga in the chat said, an EDB planner would be rad. I'm struggling as usual to find the perfect planner. Here's the problem with ADHD is there is a perfect planner. for 2 months at a time only. And then it has to be a completely different planner because the dopamine is in buying the planner, not always in using the planner. I keep going back and forth between a planner on paper, which is why I've switched to notebooks and then switched to digital notebooks because then I lose. We went back and forth. But I love the digital for the court notes so I don't fill up everything and that can be stored and sorted. I use physical notebooks for like life thoughts and other to-dos. I'm going to just write legal on the top of it. Legal, cannot search. It's my to-dos. But buying the planner is really where the dopamine is. And I've gone back to planning everything in Google Calendar. It's not very exciting. Casey Cat, there is one in the chat, an octopus emoji, but are you asking for like a custom one? Like EDB X Octonation. We'll have to ask Octonation. Ashley asked Laundered bullet journal. Bullet journal is on my list of different types of journals and notebooks I would like to bring to the Launderds. Your excitement for the Laundered Shop 2.0 is so cute. It's nice to see you. So happy. I'm so excited. It's really fun. And I enjoy stuff. I know you guys enjoy stuff. I enjoy a lot of you have asked over the years, like, it would be great if we could have hoodies in more colors. It would be great if we could have, this or that. And it's been trying to make sure that we, A, can source it, B, we can get it to you, C, it is consistent quality, and D, it's amazing and soft and comfy. And it is, it is a thing that takes time. So almost 2 years as a member. David, congratulations. That's amazing. Shao Ray, it's also your birthday. It's my birthday. I am happy. 56. Congratulations. So many birthdays in the chat. You guys are ready. You're like, whatever. Pluto's moving signs. We got a new year coming. It's all the birthdays. Let's go. Let's go. Awkward Aquarian said 4 months. Thanks you for cultivating a safe and welcoming space in the growing sea of fuckery online. You are welcome. We are well, no. We like to observe the fuckery from afar. We like a safe space to sit here and go, oh my God, can you believe that that's happening? What? Here's what I love about fuckery in court. There are times that I'm like, I can't believe this is happening. And then there's times that I'm like, tell me everything I want to watch from the sidelines. Look, we're observers here. We're not interacting. We're not getting into the fuckery. We're just observing the fuckery from afar. But what I love about the fuckery in the court is there's always process. There's always an opportunity for somebody to respond. Adcomet, this is the best way to say that. See the story, don't be the story. 10 out of 10. Miku said, we aren't touching the poop. Yes, in the words of Runkle, we aren't touching the poop. Don't touch the poop. We're just sitting back from here being observers. We're not instigators. We're not getting involved. We're watching it. Christine said, not our circus, not our fuckery. Nope, we just get to watch. But the court fuckery, there's process, right? There's always a chance to respond. So unlike like reality TV shows where you don't really, unless you're on Orange County and then you've got Emily in there Emily Simpson is going to just be like, she's the one. I have questions. I have questions. So the girl's going to get to the bottom of answers because lawyer. There are lawyers on lots of other franchises as well, but she is going to get to the bottom of anything you're saying. She's like, excuse me, there are internal inconsistencies with your argument, and I feel like you're straw manning. So I have questions. But you don't always get to the answers of it. And there's too many things happening outside in the franchises where it's like somebody said something on a podcast and somebody said this there. It's too much. In court, even if there's stuff going on outside of court, what's going on inside of court is a fairly narrowed scope. So you don't have to know everything about everything. What you need to know is brought to you from the parties. And if a party brings you fuckery, the other party is going to be like, ooh, bitch. Or the judge. The judge in the Diddy case is like, ooh, bitch, that's fuckery. And that's what I love about the process is we know, even though it can feel incredibly, incredibly gossipy, it goes back and forth and you can see the responses. And that is something I really appreciate. So let us continue on. Jolene, I heard about this like in a video headline that PIs are harassing YouTubers who are talking about the Diddy case. That's wild. That shouldn't be happening. Again, covering things in court it's covering things in court. Honey 2800 said if Diddy put legal on the notebook after it was photographed, is it off limits? The problem with putting legal on it after it was photographed is his attorneys represented it differently in court. Writing legal on something doesn't mean it's legal. So that doesn't mean it's legal at all. So Anne asked earlier, zip up hoodies when? Soon. Don't worry, soon. Not in this launch, in coming launches. Nathan said, longtime YouTube LawTube watchers here. I love LawTube. But it took seeing a classy lady who's in the cursey words to get my wife into LawTube too. Thank you for giving us another conjoined interest. Isn't it fun? Because then you have all different cases and personalities to talk about the fuckery. Because, oh my God, fuckery. Steven said, what I'm hearing is EDB said I lost weight because I need a smaller size. Not really the case. It's just a different fit. So don't worry. I'll always share, but yeah, just a different fit. Oh, yellow pill. There it is. The pin's going to look awesome on my lab coat. I hope so too. Is there any chance of a fitted hat down the line? Mike, I'm sure the team has noted that if we're talking about like a beanie or a more winter hat, we can talk about it, but that might not be till next fall. Cause we have requests for so many things and we want to make sure that, that you guys love it. Don't worry, Pondered merch is on the list. We had Pondered merch in store 1.0. Some of our favorites from 1.0 will be trickling out into other launches. Do not worry. We did have beanies in the old store. They did not sell great. So we will. Lynn, will you be covering the new Jussie Smollett news? I have no idea what that is, but not until after Thanksgiving. So, girl, we need black hoodies. Medicated moment. We had all of the black hoodies and then we were looking for color this launch. Do not worry. Future launches. This is the darkest your soul is getting is the rock and roll, hoodie. This is the darker, but you guys have made quite an argument for the, darker navy. So I see it. Kelly said 28 months already. It's been an amazing time. I love it. Casey Cat said, I was totally disappointed yesterday. We didn't break the Law Nerd shop. Sorry, Team Baker, but I have high hopes for today. I don't think we broke it today because we have a team that works with like touring rock stars and musicians. And so I'm like, look, if the fandoms cannot bring it down, I am confident that we have balanced it well. It is our goal not to break things. It is our goal to make sure you guys get what you want and get it shipped out in a timely fashion. Brandy Rose said, EDB, I'm blaming you for my Midas merge addiction. I'm so sorry. I'm in the same boat. Kel said, the way I want a job of paid eavesdropping. I've said it, like I mean, my license is active. I do consulting, but I'm not doing court work. There is a time in life when I might be persuaded by the U.S. Attorney's Office to be like, hey, we have like a growing reality TV division. You don't have to go to court. You don't have to litigate, but want to be part of the team? Dude, I might be convinced. Lisa said, just ordered the purple hoodie you were wearing, but I couldn't leave this community. So it would have to be the top secret. All right. I see all of the law nerds. I see you guys celebrating the shop. I appreciate it. Casey Cat, good to see you. Apocalypse said, day 15 of my cancer journey. Wish me luck. The law nerds are with you. You have tons of survivors in this chat to offer and lend support. And it is not always an easy journey, but it is definitely a worthy journey. So hang in there. We are here. Thank you for the gifted memberships. Please tell me the color and brand of your purple nail polish. I have no idea what I am wearing on my nails. I think I am wearing Linkin Park After Dark with a topper. And then it is loose glitter that has been put into gel onto the nails. But I think it is Linkin Park After Dark with a topper. Because all I've worn lately is Linkin Park After Dark. So, original E said, disrespect your surroundings. The meme is so good. The meme is so good. Nathan said, Emily, your reaction to the last day of the Baldwin trial is what got my wife to enjoy LawTube like I do. Thank you for the honest reactions. It's why I like watching things in real time. There are times that I am a little bit, I'll be honest, there are times where I'm like, it would be nice to be able to recap, skip through the boring stuff, get to the important stuff, know where the big moments are going to be. But I also like watching it with all of you going, oh, what just happened? So I don't think I could give it up. But occasionally, like with the Judge Jumper trial, it was really nice to get to go in and summarize that after it was done because it was kind of brief and we got to go through it. So that was really, really nice. Ice Ice Baby said, I seriously need to work and you stepped on your own dick in my sessions today. You seriously made me chortle. They did. They completely stepped on their own dick with that. I don't know. There isn't a better phrase for that. Tina KS Leonard, thank you for the gift of memberships. It just is what it is. Minnie Red said almost 2 years member, but been following since Dep. That was a lot. Jamie, stop spying on our law nerd conversations with Team Baker. For all the Team Baker members listening, Jamie said, we need lanyards for our work badges. 10-4. It may or may not be already in the works. So no worries. Emily, have you already given a spoiler to the next launch? Don't tell anybody. It's going to be fine. It's fine. It's fine. Nathan said, if the court says be prepared to explain yourself, you're already far too deep in the shit to get out cleanly. In too deep and not a good way. Not a good way at all. Mary said, Emily, I'm recovering from a uterus procedure. Good recovery. If we are thinking of the same thing, then it is not always an easy recovery. Glad I could catch you live. I'm sorry if I made you work since I am not at work. Thanks for your work. I'm glad you seem to be feeling better. I am. Today is the first day I really am feeling better, which is probably because I have passed being sick along to Chris on our team. I mean, we don't live in the same state, but it seems timing wise I've handed the baton, but I am finally starting to feel better. It's been like over 2.5 weeks. Lisa said 1 month, yeet appendix. Happy to be here. Glad you are recovering. Totes EDB with me while I organize my kiddos' room. Well, I'm here to chat along with you as you're doing all the things. I'm going to get to just a few more, and then we're going to go forward. Let's see. Legal question, just because we're going to ponder this together. Bags don't count towards having too much, right? Because they're totally storage and storage items don't count as possessions. Yes. Legal advice. They are not things. They are not things. I love the chat that's like, uterus, I'm dead. Yes, the uterus. Cole asked for iron-on pouches. I get it. Slayer said, as a November baby, a certain romantic holiday was 9 months ago. It's fair enough. Lots of birthdays in the chat. I see you. Megan has made a plea for workout gear. Casey Cat shared about one of our law nerds. I'm going to pull that up at the end as we wrap up our stream. One, Nippy Hippie said, Survivor here, love to all the recently diagnosed. And Rachel said, just patiently waiting for Shop 2.0 stickers. There are some in the in this notebook, but do not worry. Cena Bird said, Fred and George merch, ? There may be some Fred and George references in the gift with purchase. You will see those when you get them. So, Interlocution said, whenever you say YSL, I get confused because I keep thinking of Yves Saint Laurent, the designer brand, not the trial. That is fair. That is very fair. Casey Cat shared in the chat, and this will be our last chat before we depart. Casey Cat said, Dr. Moo in the chat was diagnosed with terminal pancreatic cancer in July. Can all of the law nerds please send love and support? Yes, we love Dr. Moo in the chat. We love seeing Dr. Moo in the chat. And of course, all the law nerds, and I'm sure have already responded to the super chat with all of the love and support, and to see Dr. Moo soon. So yes, absolutely, Dr. Moo, we are thinking of you. Pancreatic cancer is hard and touches too many of our lives. So I get it. And we are sending all of our thoughts and love to Dr. Moo. Angie sent a super chat about Dr. B. That is a very good point. We have talked about it briefly. Angie was asking about the TikTok veneer techs. Dr. B and I have talked about it briefly because he teaches at a dental school. And I was like, dude, are the dental students talking about this? And they had, but we haven't gotten too deep into it. Maybe we'll show him some of those. Maybe we'll pull some of those up. So thank you, chat, for all of the love to Dr. Moo. And Dr. Moo, when you see this, or if you are in the chat, I hope you feel all of the love sent by the law nerds. And we hope that all of the court fuckery is keeping you very amused. So we are here. All right, law nerds, thank you. What, always great to be with you guys. I will see you more than I anticipated next week. It's fine, Emily, it's fine. We have some time off. We will be here Tuesday. Other things will drop throughout the week, and I appreciate you. So absolutely love it. Dr. Moo, good to see you in the chat. Thank you. All right, you guys, I will see you soon. Take care of yourselves. There will be updates on Monday. Make sure you have the app so you know where they are. Go subscribe to Quick Bits, because now trial coverage is really split, or our case coverage is really split between two channels. Those Monday episodes cover a lot of cases that I haven't covered on stream yet. So they are the prequel, and we need all of them wrapped together. So with that, I will see you soon. I'm definitely looking forward to seeing you guys next week. I want to know what's going to happen in this hearing on Friday. So stay tuned, law nerds, and thank you for all the love for Law Nerd Shop 2.0. Bye. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com, or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a law nerd.